Court officer. Court officer.
ನ್ಯಾಯಾಧೀಶರ ಆದೇಶ ಅಂತ ಹಂಗಂತ ಹಾಕೋದು ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ. ಹಲೋ ಹೇಳಿ ಮೇಡಮ್. ಹಲೋ ಮೇಡಮ್ ಹೇಳಿ.
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್. ಹಲೋ
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ಇದು ಇವತ್ತು 2:30ಗೆ ಲಿಸ್ಟಿಂಗ್ ಮಾಡಿಸ್ಲಿಕ್ಕೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ. ಯಾವಾಗ ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್?
ಇವಾಗ ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ನಿಮ್ ಕೇಸ್ ಕೋರ್ಟ್ ಇದ್ರಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು ಮೇಡಮ್, 2ನೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 121ನೇ ಕೇಸ್ ನಂಬರ್ ಮೇಡಮ್, ಲಿಸ್ಟ್ ನಂಬರ್ 2.
ನೀವು ಇವತ್ತೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇದೆ, ನಮ್ಗೆ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಅಂತ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. 10:30ಗೆ ಮೂವ್ ಮಾಡ್ಬೇಕು. ನೀವು ಮಧ್ಯದಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ರೆ ತಗೊಳಲ್ಲ.
ಸರಿ ಸರ್, ಸರಿ ಸರಿ, ನಾನು ಮಾಡ್ತೀನಿ ಮೇಡಮ್.
10:30ಗೆನೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬಿಟ್ಟು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವತ್ತೇ ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಸರಿ ಮೇಡಮ್, ಸರಿ, ನಾನು ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು.
ಆಯ್ತಾಯ್ತು, ಓಕೆ.
ಹಾಂ.
ಸಿಗಷ್ಟೇ. ಇನ್ಯಾವ್ದಾದ್ರು ಇದ್ರೆ ಹೇಳ್ಬಿಡಿ 2:30 ಮೂವ್ ಮಾಡೋದಿತ್ತು ಅಂದ್ರೆ. ಆಮೇಲೆ ತಗೊಳ್ಳೋದಿಲ್ಲ ಇವ್ರೆ 10:30 ಅಷ್ಟೇ. ಅರ್ಜೆನ್ಸಿ ಇರೋದು 2:30 ಬೇಕು ಅನ್ನೋರು ಹೇಳ್ಬಿಡ್ಬೇಕು ಇವಾಗ್ಲೇ.
That's what I want to take adjournment.
ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕರೆಯಲ್ಲ ಸರ್, ಡೋಂಟ್ ಕಾಲ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಎಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಯಾವ್ದು ಕೇಸ್ ನಾವು ತೆಗಿಯಲ್ಲ ಲಿಸ್ಟ್ ಇಂದ. ಇಟ್ ವಿಲ್ ಬಿ ದೇರ್ ಇನ್ ದ ಲಿಸ್ಟ್, ರೀಚ್ ಆದಾಗ ನೋಡ್ಕೊಂಡು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ. ವಿ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಔಟ್ ದ ಕೇಸಸ್ ಅನ್ಲೆಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿಲ್ಲ ಅಂತ. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಸೆಲ್ ನಂಬರ್ 40 ನಾ 40 ಯಾವ ಲಿಸ್ಟ್? 2:30ಗೆ 7, 8, 40, 42. ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇಲ್ಲ ಸರ್, ಎಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಯಾವುದು ತೆಗೆಯಲ್ಲ ನಾವು, ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇಲ್ಲ ಆಗೋದು ಇಲ್ಲ, ಅಡ್ಜಸ್ಟ್ಮೆಂಟು ಇರಲ್ಲ, ಇಲ್ಲಿ ಇರುತ್ತೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್. ಅರ್ಜೆನ್ಸಿ ಇರೋದು ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ 62, 118, 207, ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ 7, 8, 40 and 42.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ 121 ಲಿಸ್ಟ್ 2 ಅಲ್ಲೂ
ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ 121 ಸರ್?
ಹೌದು ಮೇಡಮ್.
I will call that case. I will call that serial number. Whatever the urgency you have to mention at 2:30 now itself, sir.
Okay. I'll make a mentioning, madam. I'll make a mention.
Okay.
Thank you.
My lords, I appeared for respondent number 6 and 7 yesterday in list number 2, serial number 8. I may be permitted to file my written submissions by filing a copy to the petitioner, my lords, in the registry. Much obliged.
Serial number 118, list number 2, my lord. Suit for bare injunction. I filed by the before the
I
trial.
will call, sir. I will call. The urgency mention matters in list number 2, serial number 62.
Your lords, for the petitioner in this case, your lords, previously your lords have passed the orders regarding the matter, your lords, a DRT matter, your lords. The opposite has not complied with it. There was attachment of the property in that, and we have paid the amount, your lords. The matter may be taken up at 2:30, your lords. It is a DRT matter, your lords. In the previous occasion, we were supposed to pay certain sum of amount on 25th of every month for the 6 months. At the same time, we have filed an application to get back our property because we have paid the amount. Every month we are paying the amount. The opposite have not complied with it, your lords. So we have filed.
No, 2:30.
My lord,
Tomorrow.
my lord, fresh
My
matter.
lord,
In the first place.
My lord, fresh matter. The matter before the
Matter,
trial.
give it to the court officer. It will come.
Serial number 118.
I appear for petitioner, my lord.
What is the urgency? Only urgency is matter coming up before the trial court tomorrow. No other thing is urgent.
No, that is not my. I filed a suit for bare injunction. The trial court refused to give the injunction. Hence, I filed a writ petition before this honorable court. There is a monsoon season. Now we have to agriculture activities. The defendant trying to interfere. Hence, I filed writ petition. The matter listed. The notice has been served. D1 also death, my lord. The suit for bare injunction. Hence, the agriculture activities were unable to get in our scheduled property. We purchased the property in 1969.
When did you file the writ petition?
My lord.
When was the writ petition filed?
2026, my lord.
When? 2026 when?
Earlier to the vacation before, my lord.
That is a problem. If you look at the list, all 2026 which are moved either in April or in the vacation quarter. Now, if I take one matter of yours, it is very difficult for the court. That's why I am accept matters where the suit is coming up for hearing before the court tomorrow. Only those matters I am taking up. Remaining matters that will be in the list. Whenever I'll be able to reach, I'll reach. Because I can't take that matter. Yes, next.
121. List 2, 121.
My lords, for petitioner in list 2 121, my lord.
Memos to the court officer. Yes.
My lords, in list 2 121, my lords, case is listed up for hearing today, my lords. Henceforth, it was very much urgent, my lord.
Yes, 230, that matter 230.
207, list to
My lord, this
207.
is the matter, my lord. Supreme Court direction was there of 6 months, which just expired also, my lord. That's why my lords had heard.
Expire.
It's already just expired, my lord. We had heard, my lords had heard it last week also for some time. Then the respondent, after I argued, then they submitted that there. 207, my lord. In list 2. 3 matters are clubbed together.
1 minute.
Page number 47.
Yesterday also somebody has made a mention.
At the end of the day, we made a mention, my lord.
We will see.
Because last time you had mentioned that.
We will see.
mention.
Next week you make a mention. Yes.
List number 3, serial number 7. Urgency mentioned.
Hearing for petition, my lord. In this petition, my lord, in this, my lord, the respondent number has filed the second round of FDP without having no cause of action and without having the.
Not on the merits of the matter. Why it should be taken up today?
Well, there isn't no stay in the matter. He is trying to trespass the over the scheduled
It's not the
property.
urgency. Yes.
Serial number 8.
Your lordship, this matter, your lordship, ex parte eviction order is passed, your lordships. Now the Waqf committee, they are interfering in my possession.
That is in every case.
Yeah.
Every civil suit, every injunction, like interference, that's all common for everyone.
Yes.
Only a thing is, why should it be taken out of turn? Only reason I said, if it is coming up before the court, I'll take up.
Yes, sir.
Or else it will be there in the list.
Now his family and his are like repeatedly been troubled by the Waqf property tribunal.
On the
your
list.
lordship.
Serial number 40. Well, 2 more matters.
Yes.
Serial number 40.
Lord, in this I am appearing for the respondent. The petitioner has obtained an interim order before issuance of notice to the respondent. Now already the property is being vacated through the court order. The tenants have been vacated. Now the urgency is, my lord, he might induct new tenant again. It will become a new exercise for me to vacate them. That's the reason.
It will come. Yes.
42. 42.
Lord, I appear for the respondent. The Lord had granted a stay of an ex parte injunction granted by the trial court, whereby the trial court had directed the developer not to deliver vacant possession
Or in the first list.
to 230.
Yes.
Great.
List number 1. For others matter, serial number.
List number 3, item number 95, your lordship, sir, suit is not maintainable. We have filed an application for rejection of the suit, and that was dismissed, your lordship. Against that, CRP was filed in
That's true, but there is no
20
urgency for that.
2022, your lordship. I only request your lordship may kindly fix a date at 2:15.
No. It will be there in the list whenever it reaches, it reaches.
Because I have been taking your lordship, sir, memos, sir. I only pray your lordship.
Because you have taken the memos, it will be in the list.
No,
It is
I
there
only
in the
pray
list, it will
any
be
date
in
your
the-
lordship may kindly.
I can't give any date. Whenever I can complete, then only, because I can't
Be-
take that kind of.
Because I am from outstation, your lordship may kindly permit me to
You can
appear.
see from the internet when it will reach. I can't do more than 40 matters a day.
No,
Accordingly, it
that
will
is
come.
there, your lordship, any date convenient to your lordship.
How can I say any date?
Yeah.
Because everybody, if there are so many matters, they also have the urgency.
No, I am not saying your lordship, the suit trial is being completed and it's a waste of the,
That is the urgency in every case.
no, my submission is
I can't.
if your lordship
I can't
consults,
give any date. If I want, I give you a date in August 3rd.
your lordship,
August 3rd.
no, not August, your lordship.
There are so many matters, please
No.
understand. Yes,
May I
make a
mention
Much
for
of-
adjournment, my lord? Can I make one request?
yes.
Serial number 52 in third list. Parties are trying to settle.
Serial
the-
number?
52.
In list 1.
List 3, my.
Uh,
Your lordships could refer the matter to Karnataka Mediation Center, there will be settlement.
what about the other side?
He is present, party is present.
Not the party. Where is the council?
Council, I have informed him. We have also prepared a memo. It has been on discussion only, we have prepared.
Call that matter at 2:30.
Yes, ma'am.
Lords, may I-
52.
may I make a mention for adjournment, my lords. List 2, serial number 152, my lords. It may be listed in the first week of July, my lords.
It will reach in first week of July. Wait.
List number 1 for orders matter, serial number 1. Ravi Shankar case.
It will not take more than 5 minutes.
No, every matter will not take more than 5 minutes. But
I only
can't take.
request your lordship may kindly.
I cannot take, Mr. Counsel. Please understand, I will not take any. It is no ad stick for one advocate, one and the other one. For everybody, only one ad.
I am not taking.
That is what is the procedure of the court. Why should I deviate from that? Yes.
Much obliged.
My lord, office has raised objection regarding maintainability, my lord.
What is
Well,
this writ petition?
My lord, I challenge the order passed on order 21 rule 58 application for objector to the execution proceedings came to be rejected by the trial court, my lord.
Then you have to
Whether
file an appeal.
I'll
have to
verify
file an
and
appeal.
submit before the court.
Huh?
I verify and submit before this court.
What verify? What will you verify?
Please, ma'am. Liberty, ma'am.
Office has raised an objection with regard to maintainability as a writ petition that is filed.
Revision petition.
The revision that is filed is against an order where the application filed with objector under Order 21 Rule 58, read to Section 151 CPC is rejected. Land Council, the petitioner submits that. Appeal lies to this court or district court?
District.
It is submitted that the Land Council submitted the liberty may be granted accordingly. Office objections are sustained and the CRP is disposed of, giving liberty to the petitioner to approach the appropriate court within a period of 10 days from the date of receipt of the copy of the order. Yes.
Directed to return the document.
Directed to return all the documents.
Please.
Pascal Gowda.
Yes. There is that memo.
My lord, this is a day before yesterday's matter. My lord, I had filed a memo, my lord, seeking withdrawal of IA for leave. And also I have filed a memo amending the cause title, transposing petitioners number 1, 2, 3 as additional respondents.
Memo is filed. That's I number 2 of 26 is filed. Seeking leave of the court to withdraw I number 2 of 26. Accordingly, petition for the I number 2 of 26 is dismissed as withdrawn. Next, where is the other one?
My lord, I filed memo, please, my lord, the amended cause title.
Where is that?
It is yesterday we have filed. My lord. I have transposed petitions number 1, 2, 3, please, my lord, as additional respondents.
Where is that?
My lord, memo.
I have seen them. I'm looking at it.
Please, my lord. I have transposed, please, my lord, petitions number 1, 2, 3 as respondents, please, my lord, 9 to 11. My lord,
They are yet to be added.
my lord, I have transposed.
Oh, before the suit, they were not added.
Before the suit, please, my lord, they were
Then
not
however,
added.
how you can straight away add them? That is the question.
My lord, that is the reason, please, my lord, I filed and my lord, application seeking leave.
Don't make them a parties to this.
Please, my lord, I'll delete it.
That amendment you have to please carry out.
Please, my lord,
It can't be taken as it
my lord,
is.
I'll file a fresh.
The petitioner in the amended cause title has made the LRs of plaintiff number 1
Please.
as the respondent number 9, 10 and 11. They were not, they were not impleted before the trial court, and straight away petitioner cannot show them as respondents, and accordingly the petitioner shall make the necessary corrections.
My lord, the agency would be, please, my lord, what has happened? My lord, plaintiffs, please, my lord, they filed a suit for partition, please, my lord. My lord, I am before this court, please, my lord, agreed by the my lord, non-refusing to grant an ex parte injunction. May I take your lordships to the my lord, the earlier proceedings, page 28. Page 28, please, my lord. My lord, first plaintiff is Muni Appayanna. My lord, he is the defendant number 1 in the present suit.
Before you go to that, what is the IA? That I should
My lord,
know.
39 to 1 and 2 not to alienate, please, my lord. Emergent notice has been issued by the trial court. That is what being challenged, please, my lord. If your lordship would,
I'll set aside that order. I'll ask the court.
my lord, what has happened, please, my lord, it was filed in the vacation. My lord, now the my lord, the notice is also not
So
issued.
filed an ad interim injunction application, court has to decide it. I'll say without note, whether notice is served on the respondents or not, whether entitled an ad interim injunction or not, let the court decide.
My lord, now please, my lord,
Call them here, let them appear there.
my lord, now what the urgency would be, please, my lord, now please, my lord, the first
Come
defendant.
to a court where when your relief is somewhere, you come here and say urgency.
My lord, if your lordship would peruse the impugned order for a moment, absolutely, please, my lord, there is no application of mine.
No, you say that notice is ordered.
My lord, notice is ordered, but please, my lord, notice is not issued by the office is concerned. Why? Because, please, my lord, the vacation district court, please, my lord, it lies within the jurisdiction of the Bangalore. Now the suit is
I'll
coming
ask
up.
the court to decide it within a week by setting aside this order, that they have to give reasons on that.
Please, my lord.
Whether you're entitled for injunction or not.
Yes, please, my lord.
Please come. Where is that order?
My lord, impugned order, please, my lord, would be at page 20, commencing from page 22, please, my lord.
The petitioner, who is the plaintiff in the suit, is agreed with the order, agreed with the proceedings dated 25/20/26, 25/20/26.
Please, my lord.
Whereby the court,
27/5/26.
27/5/2026. Had issued suit summons to the defendants on I number 1, which is filed filed seeking ad interim injunction. It is submitted with the learned counsel to the petitioner that when an application is filed seeking ad interim injunction, the court, if the court is inclined to grant an order, the court has to grant an order, or the court has to dismiss the same, but it cannot order summons to the respondents considering the agency as put forth by the so-and-so in the light of the law laid down in so-and-so. The PK and the judgment is there. PK. In the light of the so-and-so, the order dated so-and-so is set aside and the matter is remanded to the court, and the court shall consider the IA that is filed by the petitioner on the merits of it within a period of 1 week from the date of receipt of the copy of the order. Yes, next.
Lord, within time frame.
1 week, I said.
Please, my lord.
And get the order copy today itself.
My lord, without insisting the, my lord, presence
That's
of the.
what I said.
Please, my lord.
That is what the judgment I referred in that.
Please, please, my lord.
Disposed of. Yes, 3.
My lord, the suit for partition, the subjections is regarding 2 IAs to be clarified. IA number 1 is reopen of cross-examination.
This office objections are over. Yes.
My lord, this is a suit for partition,
Considering the fact
wherein the petition,
it's a common order.
wherein the petitioner is seeking for equal partition from her father's property and declaration that she is an absolute owner of Schedule C.
What is IA?
IA on 6/4/2026, my lord.
Suit is of the year 2008.
Suit is of the year 2008.
What is the suit for?
Suit for partition.
You are the?
I'm the plaintiff, petitioner.
When was the evidence come closed?
Cross-examination was concluded in the year 2023, my lord.
Cross-examination of the defendant.
Of us, it was concluded in the year 2023. Thereafter, in the year on 1/7/2025, we placed 2 new evidences, which was marked as Exhibit 64AB and 65. Your lordship may kindly see annexure.
After your evidence is concluded, again you have marked 2 documents.
It was a previous counsel on record who was the one who cross-examined me. We undertook the case in the year 2026. On 6/4/2026, I filed an IA number 1 and 2 of 2026 under Order 18, Rule 17, read with Section 151 of CPC. But then on 9/4/2026, the learned trial court judge rejected the IA, my lord.
Come to the order. Page number.
Your lordship may kindly see. Page 14, page 49. Orders on IA number 1/2026 and 2/2020 instant application have been filed by counsel for plaintiff under section 151 of CPC, requesting the court to reopen the case and recall DW1 for further cross-examination. The learned counsel for defendant number 1 has filed detailed objection contending that on 26/2/2020, case was posted for cross of DW1. On 12/3/2020, DW1 was partly cross-examined by counsel for plaintiff. On 7/1/2021, as counsel for plaintiff was absent, court was pleased to discharge DW1 and the matter posted for arguments on MAME. Upon application of plaintiff, further cross-examination of DW1 was partly done on 28/9/2021. Thereafter, plaintiff changed her counsel and further cross-examination of DW1 done on 27/6/2022 and 22/2023. On 6/3/2023, matter adjourned for further cross-examination of DW1 by plaintiff. On 6/3/2023, counsel for plaintiff submitted that there is no further cross-examination of DW1. In view of the submission of counsel for plaintiff, matter was adjourned for cross-examination of DW1 by defendant number 2. Cross-examination of DW1 has been done on 4 occasions by covering all aspects of the matter, but still Plaintiff has sworn to an affidavit contrary to facts available on record. There are no bona fide in application and question of reopening the
Where
case.
is your IA?
The Lordship may kindly see 43.
40?
I'm sorry, madam. 42. Affidavit. I am the plaintiff in the above case and well conversant with the facts of the case. Hence, I am swearing to this affidavit. I submit that on 12/3/2025, this honorable court.
42.
Sorry?
42.
42.
It's not 42.
Hold on. Apologies, my lord. There's some mismatch with the page number.
I think this is at 63. Sure. At 63 it is. What did you say in the affidavit? Read it. Give it to him.
I am the plaintiff in the above case and well conversant with the facts of the case. Hence, I am swearing to this affidavit. I submit that on 12/3/2025, this honorable court was pleased to pose the case for arguments on 6/4/2026. I submit that cross-examination of DW1 was not completed and further conducting cross-examination of DW1 is very much required. And I have instructed.
File an application when the matter is posted for argument and when the cross was closed 3 years ago. And is this the affidavit? Basing on this, the court has to reopen it?
My only contention, my lord.
Where is that? Not contention. What is your case? What is the purpose of filing an affidavit accompanying an IA? You don't say anything. 3 years back, it is completed. And you said that there is no further cross-examination. Matter is coming up for arguments. And you file this IA without any reasons.
It was a previous counsel on record of cross. And
what is the present counsel doing? Affidavit is filed by the present, the instructions of present counsel. Yes, dismissed. Order will follow. Yes, next.
Cell number 4.
My lords, I appear for the petitioner in this matter.
Yes.
Office objection, my lords, is relating to maintainability of my lords writ petition filed challenging orders on 2 IAs.
What are the 2 IAs?
My lords, it's recall and reopen, my lords, and it's a
Yes.
common order.
See, office objection overruled. As it is submitted that it's a common order. Yes.
My lords, the applications, my lords, came to be filed on 28th October 2025. When my lords further cross-examination of.
Please give the details. When
Please,
which
I
year
am the
is the
defendant
suit?
in the suit.
What is
suit
the
is for recovery of money.
Which year is the suit?
My lords, 2019.
You are the?
I am the defendant, my lords. It's a suit for recovery of money. It's an employment dispute. The employee files, my lords, against the company. I represent the company. My lords, on 3/12/2025, my lords, the matter was posted for cross-examination of PW1. Then, my lords, on several dates, my lords, PW1 was absent. On a few dates, my lords, I have to admit, we also took time for cross-examination. On 23rd August 2025, my lords, PW1 was partly cross-examined and the matter was adjourned to 19th September 2025. On 19th September 2025, my lords, on account of the fact that the counsel was unwell, time was sought, my lords, by the defendant or petitioner herein. My lord, that prayer was rejected on the ground that, my lords, PW1 is traveling to America and therefore no further time can be granted and cross-examination right was closed. But matter was posted, my lords, to 28 October for further plaintiff evidence. Witness was not discharged, my lords, on the day on 19/9/2025. On 28th October, my lords, I filed 2 applications, my lords, IA number 4 and IA number 5 for recalling and reopen the stage for further cross-examination. Please, my lords. My lord, the order is at page 24, annexure A. And my lord, the reasons, my lord, start at page 27.
Yes.
May I read from page 27, my lord?
Yes.
Plaintiff filed the suit for recovery of money. After framing of issues, plaintiff examined himself as PW1 by filing his affidavit in lieu of examination in chief. On 11/11/2024, case was posted for cross-examination of PW1. PW1 was present on 3/2/2025. On that day, advocate for defendant prayed time for cross-examination. Thereafter, on 15/4/2025, PW1 was present and time for cross-examination was granted on cost of rupees 500. Thereafter, on 15/7/2025, PW1 was present. Again, advocate for defendant sought time for cross-examination of PW1 and time was granted on cost of rupees 500. Thereafter, on 12/8/2025, PW1 was present. Again, advocate for defendant sought time for.
How many times the court has imposed costs on you?
My lords, may please see the entire order sheet. On multiple dates, my lords, PW1 was absent. In fact, my lord, there are orders to the effect, my lords, where the plaintiff counsel was directed to keep PW1 present. But I admit, my lords, I have taken time on 3 occasions. On 23/8, my lords, I cross-examined, my lords, the witness partly.
How many
PW1.
times the costs were imposed?
My lords, costs were imposed 3 times, my lords, during cross-examination of PW1.
Why do you seek time every time whenever the matter is listed?
My lords, there were various difficulties at certain times, my lords, and my lords, I was not the counsel, my lords, in during some of those days. But I agree,
I
my
don't
lords.
expect that
That's
answer
not a
because we are not concerned with the council, we are
Please.
concerned with the party.
Please, my lords, I understand. My lords, but also, my lords, if my lords may peruse the order sheet, my lords, on multiple occasions, my lords, PW1 was absent. However, my lords, no coercive orders were passed, my lords, on those dates. If I could take my lords through the order sheet at page 93, 92 and 93, my lords.
No, PW1 has his own difficulties. He has to forever, whenever he'll not be waiting that till the defendant cross-examines him.
My lords, I understand, my lords, but the trial court has proceeded, my lords, on an erroneous basis to say that he's traveling to the US. They don't know when he is back, and therefore, my lords, time cannot be granted for cross-examination. My lords,
No, you cannot ask all these questions having not cross-examined him on so many occasions.
My lords, I cross-examined him on one occasion, my lords, on 23/8, and then, my lords, for further cross-examination. My lords, all my prayer is, my lords, I just need one date for cross-examination. I undertake, my lords, not to take any time.
Court was giving you that prayer, you're not going ahead with that. And why do you come to this court and say that only you want one day? That's what the court also said. Do it in one day.
My lords, on 19/9, my lords, the counsel was unwell, my lords, therefore we took time. On which date, my lords, my right
Let's
to
see your
cross-examine.
affidavit. What did you say?
My lords, the applications, my lords, I have filed on
You
memorandum
can't
of
take
facts.
the court very casually like this.
My lords, I understand, my lords, and
it has become a practice that asking for time before the trial court is it's a matter of right. And let the court do anything, we'll go to the High Court and get the order from the High Court.
my lords, that's not the case, my lords. My lords, the only circumstance in this, my lords, is that
No circumstances. Let's see your IA. That's fine. What circumstances you have explained?
my lords, I have filed, my lords, IA number 4.
Which paragraph? Which page is the affidavit?
At page number 66 is the application, my lord. The memorandum of facts starts at page 67.
Let's read that. What did you say?
My lord, the relevant paragraph is paragraph 3.
Please read.
PW1 filed his affidavit in lieu of examination in chief on 24 June 2024, and on 31st July 2024, exhibit P1 to P10 were marked in evidence. Consequently, the matter was posted for further chief examination, and on 11th November 2024, the counsel for plaintiff submitted that there was no further chief and the matter was posted for cross-examination. On 23/8/2025, PW1 was cross-examined partly, and the counsel for defendant and the matter was posted for further cross-examination on 19 September 2025. On 19 September 2025, the counsel for defendant was unwell and hence was not in a position to cross-examine PW1 and sought a short adjournment. Since PW1 was traveling abroad, this honorable court rejected the prayer for adjournment made by counsel.
You do not say anything about how many times why you have not, cross-examined him.
My lords, I argued that, my lords, while arguing the IA, it's not on the memorandum of facts, but my lord, that has been considered by the trial court in the impugned order. My lords, all my prayer is, my lord, that I will undertake not to take an adjournment.
I'm telling you, I'll issue notice, but I'll impose cost of 10,000 on the defendant. If you are ready for that, I'll grant an interim order.
My lord, some lesser cost.
If you are ready for the cost, then an order will permit you to cross-examine.
Please, my lord.
When counsel for the petition submits that, the defendant has filed an IA seeking reopen and recall PW1 for further cross-examination. The court, without considering the same, has dismissed the application. It is submitted that once one opportunity is granted, the petitioner in one day will complete the cross-examination of the plaintiff. This court has perused the order and also on how many occasions the defendant has failed to cross-examine the PW1 and which made the court to pass the order. However, this is a suit of the year 2019 and considering the request of the petitioner, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 10,000 to the plaintiff, to the defendant, Next, the petition is permitted to take out hand summons on the council appearing to the respondent and file a memo to that effect by 23rd of June. List this matter in first list on 24th. If the memo is not filed, the stay granted by this court stands vacated.
Let's see if there may be some concession on the cost. Malad.
5,000.
Much of.
Number 5.
This is that matter, yesterday's matter.
Yes, what do you say?
That one corrections flood that yesterday because that copies served 1 o'clock.
Yes.
I'm not able to full securing the information. So that this scheme has been that approved in the month of February 2025.
That is the SOP with regard to
That in SOP, that is the scheme for execution of the work. That
February?
it is in a determination of the compensation, what that they are submitting is concerned. That notification has been published in the month of that in the April. The tower that check survey conducted in the month of July. That immediately that in the 1/9/2025 we are requested to the deputy commissioner based on the circulars that the determination of the compensation to this line is concerned. Right, it is under process that the determination of the compensation. But during in the meanwhile that we are started the work so far as that it is concerned.
So that is where the question is, as per that notification, are you permitted to do so even before the compensation is determined?
The determination compensation is different, damages with regard to execution work is entirely
He
different.
was reading something that without doing it, you can't do it.
Just pass on the
Circular.
Give him the copy of it.
if your lordship sees the SOP,
Yes,
my lords,
that's on the last page.
last but one page, my lords, it's a flow chart that is given. If your lordship sees the flow chart,
Hmm.
my lords, how the procedure has to be followed. Identify landowners and issue notice to proceed. That is TSP means transmission service provider, my lords. Collect documents, verify land records with revenue maps in case of multiple landowners, obtain NOC from all. Measure tower footing or corridor area in the presence of landowners and obtain the signature of landowners or revenue authority. This has not been done, my lords. In case of grievance relating to land rates, DM to issue orders on land rates, DM or authorized executive magistrate to fix compensation. TSP to pay compensation, compensation payment to include tower footing, so and so, the parameters for which the compensation is. Disperse the payment by the TSP and collect receipt from the landowners. My lords may now come back to clause 9, my lords, of this particular circular. That is at page 3 of 3, bottom page 3 of 3.
Yes.
Compensation payment, my lords, shall be one time and upfront. Wherever possible, compensation shall be paid through various digital payment modes. Now, my lords, why this circular has been issued, my lords, in light of the Honorable Supreme Court's judgment?
No. From this circular, where do you get that without paying the amount,
Please, my lords.
they cannot lay the transmission lines?
My lords, from this circular, my lords, the only word that is used is compensation, and that flow chart is provided, my lords. Apart from
How they have to do it, but at the same time, nowhere it says that first you pay the compensation, then you lay the line, because you are entitled for compensation. Compensation has to be as per this.
Please, my
No, even this measuring and all
Please.
should be done in your presence.
Please, my lords.
To that extent, you can seek for a relief from the court, but you cannot say they cannot lay the lines.
My lords,
Unless and until
I
they.
am not challenging for a moment, my lords. I am
Yesterday
not.
you were asking for stay of the.
My lords, I am not challenging the entire acquisition process. I do not want to come in the way of an infrastructure project, my lords. As long as they have followed the due process that is there.
That's
Now,
what I said. We will ask them to follow the procedure.
Please, my
But
lords.
as far as, staying the laying of those transmission lines, we will not do. That's what,
Please, my lords.
yesterday when you argued, that's what I said.
Please, my
That
lords.
even
My-
class 2 that provides a determination of the compensation is vested to the district magistrate, deputy commissioner. That we already requested, that it is in a pending consideration that where that process has to conduct.
No, the
Secure
deputy
that.
commissioner is a party to this.
Yes,
But
lords.
he is the one who's
Let
passed
him-
that order in terms of.
No, let them adhere to this SOP.
Yes, yes, lord. Yes,
Let them do as per that.
yes.
And if the inspection has to be, the measurement has to be done in
Yes,
his
yes.
presence, it should be done in his presence. Whatever it is,
Yes.
all entire this annexure 3 of the SOP shall be
Yes.
followed
Please, my lords.
in its strength.
Yes.
Yes.
That
there should not be any obstructions for execution of the
Why
work.
will they
With
They want-
fixation, my lord, that all that it has to be followed in this circle.
Because it has to happen parallelly, my lords. The only object is even the Honorable Supreme Court in Kalpataru Powers case has observed.
You have the judgment?
Please, my lords, the Kalpataru Powers case judgment I have. May I just pass on? There, my lords. My lords may kindly see paragraph 30, my lords. Paragraph 30 at internal page 30.
Yes.
Besides there being no appellate remedy, we find that there are gaps as well in the statutory scheme. A reading of provisions 10 and 16 of the 1885 Act that in addition to no remedy of appeal being provided against the order passed by the district judge, no timelines have been provided regarding the payment of compensation to parties. After the right under section 10D is exercised by the competent authority, the time during which any party can raise grievance about the sufficiency of compensation so assessed. The provisions are also silent about the time during which a landowner can file an application before the district judge in case sufficiency of compensation is disputed. The Act also does not provide the rate at which the interest is to be paid to the landowners in case there is any delay in payment of compensation. This Act being an act of the Parliament, its application has to be uniform throughout the country. In the absence of defined parameters, it will depend on how different courts interpret the provisions. In the case in hand, certain rights were taken by the authority concerned for erection of electric towers and drawing the power lines and not the ownership of the land. There are many different statutes under which the ownership of land is acquired by the competent authority in exercise of the powers conferred under those statutes. Wherever such a power is exercised, the natural corollary is the landowner is to be adequately compensated. Detailed procedure and timelines for different actions have been provided under those statutes. 31.12, my lords, 31.5, sorry, paragraph 32 is all the various different legislations, including LARR Act and the RTFS FCLRR Act. Now at paragraph 33, needless to add here that in the process of determination of compensation, evidence will have to be led by the parties unless the statutory remedy of appeal is provided where all issues of law and facts can be determined and any other remedy may be illusionary. As is noticed in the facts of the present case, the remedies availed by different parties were different. In some of the cases, writ petitions were filed by the landowners under Article 226 of the Constitution of India, impugning the judgment and decree of the civil court, and in some of the cases, the contractor as well as landowners filed petitions under Article 227 of the Constitution of India. Reappreciation of evidence in those proceedings may be an issue. The remedy may not be effective and become illusionary. And paragraph 35, my lords, in the aforesaid background, we are of the opinion that these issues need to be examined by the Law Commission of India and Ministry of Law and Justice,
yes,
Government of India. There is a lacuna in the legislation itself.
No.
Now, my lords,
No, 1 minute.
Sorry.
No, all this process has started in the month of February 2025. And now they are going to lay the lines. So in this process, they should have also completed whatever has been this procedure under.
Please, my lord. So that the deputy commissioner conducting the process. All the landowners, yesterday also meeting was fixed with landowners, including securing the market rate, sub-register value.
We'll fix a timeline for that.
And that let the director, deputy commissioner to decide that within a
How much
particular.
time?
The deputy commissioner, yes. He appears.
4 weeks. 4 weeks. 4 weeks.
Please, my lords. My only other submission, my lords, is the deputy commissioner passes an order in terms of section 10 of the Telegraph Act read with section 164 of the Electricity Act. This process has to happen parallelly. That is a process, my lords, where he will afford the laying authority a permission to enter the land and lay the lines without interference or obstruction, and if required, take police protection. When he is passing such a coercive order, my lords, it was incumbent upon him to even
he has
pass
passed an order in.
Yes, my lords, and that is what is being impugned. And on the strength of that order, they have entered the land, my lords. On the strength of that order, they have entered the land.
Please come. The present writ petition is filed, saying the following prayer. Extract the prayer. The facts of the case are: the petition is absolute owner is in lawful possession and enjoyment of the agricultural land, bearing survey number 57/2, situated at Hulinahalli village, Hopli, Hunsur Taluk, Mysore district, measuring 23 guntas. It came to the notice of the petition that the respondents are proposing to lay a 66 kV transmission line through the scheduled property and to erect towers therein. It is a case that the petitioner was not consulted, no prior notice was given to the petitioner regarding the proposed alignment. Upon learning of the proposed alignment, when certain officials from the office of respondent number 2, now, respondent number 2 is the deputy commissioner.
My lords, respondent 1, my lords. Respondent number 2 is the laying authority.
From the respondent number 2, visited the scheduled property purportedly to conduct a survey in December 2025. The petitioner addressed a written representation dated 26/12/2025 to the superintendent transmission works within brackets maintenance circle KPTCL Mysore, objecting to the proposed line passing through the scheduled property and clearly requested either relocation of the proposed alignment or acquisition of the entire extent of payment of lawful compensation. It is a case that the respondents have not passed any orders on that. It is stated that the respondent number 2 filed a petition before respondent number 1 seeking to restrain the petitioners from interfering with any of the HT line laying works in the property. Basing on the said representation, basing on the said request by the second respondent, the deputy commissioner is the first respondent or third
He's
respondent?
first respondent, my lords. There are only 2 respondents.
First respondent by order dated 5/6/2026 granted permission to respondent number 2 to enter upon the scheduled property and draw the 66 kV transmission lines and directed the police to provide protection for such purpose. Next parallel and counsel appearing for the petition supplies that basing on the same, the respondents are have entered into the petition's land and with all the material. Then at that time, the petitioner is constrained to come before this court by filing the instant writ petition. It is submitted that the Government of India, Ministry of Power, has issued the guidelines for the transmission lines dated 14/6/2024, and as per Annexure 3 of the said notification, there is a standard operation procedure. How?
One correction. Pursuant of this, the state government has to be so far as that issue circulars.
What is that?
In pursuant of this central government notification, state government has to issue notification.
There is a standard operating procedure as per the same. They have how the procedure has to be followed from the date when they have taken a decision to lay the transmission lines. It is a grievance of the petitioner. Nowhere the respondents have consulted the petitioner. No measurement is undertaken in the presence of the petitioner. And till now, the determination of compensation is not done by the respondents. And now they're going to lay the lines. It is submitted that now the petitioner's case would be at the whims and fancies of the respondents, and he cannot wait eternally till the entire process is completed by the respondents. It is submitted that the Honorable Apex Court, in case of Charger KT Transco Private Limited, in the case of Vinod and others, etc., versus Kalpataru Power Transmission Limited, arising out of SLP numbers 14936 to 14942 of 2023, has expressed concern over the procedure and how there is no timeline prescribed under the Telegraphic Act
And the Electricity Act, both.
and the Electricity Act.
That under which the dealt challenging the orders of the 16.3 and 16.4, where there is no timeline appealable. That is Malad so far as that after order of the district magistrate.
There is no timeline prescribed with regard to if the party is agreed, then what time frame he has to approach the court, and on several issues, several concerns were raised. It is submitted that the respondents cannot be permitted to use the land of a private party and at the same time deprive them from paying the compensation. Next, land counsel in the docket proceedings already I said you take notice AGA
Yes.
and you,
Two, second respond.
no. Was it ordered as
No, my lords.
in the docket? AGA takes notice on behalf of respondent number 1, on behalf of respondent 2, Devraju.
HV.
HP Devraju takes notice on behalf of second respondent, accepts notice on behalf of second respondent. Land counsel appearing for the second respondent submits that it is for the deputy commissioner to follow the procedure, and even if the petitioner, even for the petitioner also, if he is agreed, he has to approach the deputy commissioner. And as per the procedure and as per the permissions that are granted, the respondents are laying the transmission lines. It is submitted that the petitioner cannot object for laying of the transmission lines as the same is done in the larger interest of the petitioner is only entitled for compensation, and that would be determined by the deputy commissioner. It is submitted that the petitioners cannot obstruct the respondent number 2 from laying the line. Land counsel, Learned AGA, appearing on behalf of the first respondent, submits that the first respondent has passed the order as per the provisions of the Telegraphic Act, and they'll follow the procedure for paying the compensation.
But fixation of the compensation.
Fixation of the compensation, and under the Telegraphic Act, there is a remedy available to the petitioner if he is aggrieved with such an order passed by the deputy commissioner. It is submitted that there is no illegality with the order impugned, and petitioner could not make out any grounds seeking interference of this court. Next, having heard the counsels on either side, peruse the material on record. This is an admitted fact that the second respondent is going to lay the transmission lines in the property, and that the transmission lines are going through the property of the petitioner. The petitioner has placed before the court the SOP dated 14/6/2024. As for that, the procedure is contemplated under the same. It is a grievance of the petitioner that so far the petitioner, the respondents, anyone from the first respondent office or the second respondent office have not consulted the petitioner, nor he was made party to any of the measurements for any of the measurements as contemplated in the set operating procedure. It is submitted that the respondents at their convenience cannot pay the compensation when they are and the petitioner is conscious of the fact that under the Telegraphic Act, and whenever the respondents can lay their lines, but at the same time he has to be compensated sufficiently and in a time-bound manner. This court finds force in the argument of the then counsel of the petitioner, and also this court has perused the judgment of the apex court, refers to the judgment of the apex court in Kalpataru's case, refers to where the court has taken note of the difficulties of these landowners in whose lands these transmission lines are laid, and where the delay has occurred, where the delay is occurring in terms of payment, and also other issues were elaborately discussed in that view of the matter. This court is of the view that the petitioner cannot obstruct the respondents from laying the laying the transmission lines, and at the same time, the deputy commissioner, the first respondent, cannot take his sweet time in fixing the compensation, and Who will disperse? You will only disperse.
We will disperse. After
First
fixation, we will disperse.
respondent cannot take his sweet time in fixing the compensation, and the second respondent cannot take his time in dispersing the amount. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the first respondent to adhere to the SOP dated 14/6/2024 and complete the entire process within a period of 4 weeks. Thereafter, the respondents, within a period of 4 weeks from there on, the second respondent shall disperse the amount. Third, if the petition is agreed by the order of the first respondent, he is at liberty to avail the appropriate.
Under section 16(3), my lord, that before the jurisdictional district judge.
That time.
Cell number 6.
I'm grateful.
Krishnamurthy, Amma.
That one sentence, my lord, direct that petitioner also participate in the proceedings before the deputy.
Petitioner shall participate in the procedure. He should be put on notice.
Yes.
Any date may be fixed, my lords. Your lordships may fix a date and we'll.
Appear in 1 week, my lord, that like he has to go.
We'll say some date.
Yes, my lord.
Because it's 4 weeks, the petitioner, but they will communicate
Yes,
to you.
very
But fixing a date also will not, because I have the outer limit of 4 weeks is already fixed.
Please, my lords. I'm grateful.
Cell number 6, Krishnamurthy, Amma.
Appear for petitioner mallards seeking for short accommodations.
Just in the month of August.
Cell number 7. Cell number 7, Krishna S. Vas.
For representation.
I'm sorry. My lords, this is a case in which
There is no representation in the first 6 months. The petitioner has sought for time. This is a matter in the month of August. Yes.
yes. My lords, this is a case in which an application has been preferred by the petitioner in a specific performance suit when the matter has been listed for the course of examination of chief of the plaintiff, my lords. The petitioner is the plaintiff in the instant case. For summoning of documents on the very same court, my lords. The impugned order.
Suit is of the year 2006.
Yes, please, my lords. The suit had been delayed not on account of the plaintiff, my lords, but for so many other reasons, including that, my lords, there was a death of continuous parties in the proceedings. Therefore, they had to be substituted in the case.
Come to the impugned order.
I draw the attention of this honorable court to page number 94, my lords, which contains the operative portion of the order passed by the learned trial court.
It's a very short order. We'll read
yes,
it.
please, my lords. The plaintiff furnished.
From 93 we will read.
93, yes, sir. IA number 13 is filed by the plaintiff under 16 Rule 12 of Redwith so summoned original sale agreements produced in various suits from Sheristadar of Senior Civil Judge Court, Anekal, the very same court. In the accompanying affidavit, it is submitted that the original sale agreements dated so and so were produced by the plaintiff in other suits number so and so. The present suit is filed by the plaintiff for the relief of specific performance. The sale agreement produced in the above suits are relevant to prove the case of the. Hence, Sheristadar of this court may be summoned to produce the above sale agreements produced by the above suits. The above application is resisted by the defendant number 1 by filing their objections. In the objections, they have denied the averments of the above application, annexed affidavit, and contended that the above application is filed in order to track the proceedings. There is no proper explanation as to the need of summoning of those documents. Plaintiff can produce the certified copy of the document, or he may return the original document from the said suit and may produce the same before this court. Instead of invoking the remedy available under law, in order to track the proceedings, the above application came to be filed. Provisions under Order 16 Rule 12 of CPC is not applicable to the case on hand, hence the above application. Heard the arguments of the learned counsel for the plaintiff and defendant. Plaintiff want to summon the original sale agreements produced in various suits pending before this court through Sheristadar of this court. The plaintiff has furnished a list of the suits in the above application. The perusal of the list shows that all the suits were filed by the plaintiff, namely K.N. Chacko. Such being the case, the document produced by the plaintiff in other suits, he can get the documents returned from the said suit and he can produce the same before the court in the present suit. Instead of doing so, summoning of Sheristadar to produce the documents is unwarranted. Plaintiff can get the sale agreement returned in the said suit and he can produce the same before this court. If the document produced in the other suits,
why can't you do that?
So.
Why can't that?
Yes, be done? That is their actual problem here, Malad sir. The issue here is that K.N. Chacko has expired in the year 2017. Posterior to that, the LRs of the K.N. Chacko have been brought on record. Now the difficulty is that in the event that I would be applying for a copy in that case, the counsel who had been representing me has now been designated as a senior counsel. Therefore, he also cannot file a copy application or an affidavit. I cannot file it because I am not on record in the cases, because the cases came to be disposed of even before the death of Scan Chaco. I'll have to. It is a very long drawn procedure, my lords. The courts, it is on the very same court, my lords.
In counsel the petitioner submits the petition is filed I number 13 under order 16 rule 12 to summon the original sale agreements produced in various suits from the Shristathar of Senior Civil Judge Court Karnataka that came to be dismissed by the trial court on the card. Petitioner can make an application and can get the sale agreements returned in the said suit, and he can produce the same before this court. The court observed that if the suits documents produced in other suits were summoned in the suit, the other suits will be hampered. It is submitted that this is a suit of the year 2006. If the petition has to undertake the said activity, it would take a lot of time, and this aspect is not considered by the court. Considering the same, they shall receive a call for the proceeding pursuant to the order dated so and so. Petition is permitted to take court handsomely from the counsel appearing for the respondent before the trial court and file a memo to that effect by 6th of July, or else the stay granted by this court stands vacated.
Then number 8.
In the interim, my lords, the matter is already posted for evidence.
Granted.
Then number 8. Sudhendra Kumar L.
Appear for petition.
And for the respondents, 2 to 6, madam.
Yes.
The petitioner filed a suit for declaration, declaring he is the absolute owner of the property. And the respondent filed up the return statement, contending it is a self-acquired property of the father of the respondent number 2.
What is for partition? You are the plaintiff or the defendant?
No, it is only for suit for declaration, my lord.
Declaration. You are the?
I am for the plaintiff.
Yes.
Original plaintiff is my husband. After death of my husband, I came to record.
What is the IA that is filed now?
IA filed by the petitioner under Article 13 Rule 10, my lord.
Where
Summon
is
the
that?
document.
Please come to the order straight away.
Annexure is the my lord.
46, madam. Order is at 50, madam. I think page 50.
Order. Annexure is the impugned order. Page number 46, my lord. Only ground assigned by the learned judge is that there is a circular by the High Court. That's why he is unable to pass an order. To summon the document from different courts.
Now the matter is coming up for arguments.
Yes, madam.
Then why you file this application?
Because I have read upon that original
No,
partition.
what is the purpose now? No, you have the matter is posted for arguments, evidence is closed.
Yes,
Where
madam.
is IA? Where is IA that is filed by you?
Here is the annexure C.
Where is that page number?
Page 16.
36.
Annexure C, my lord. Page number 36, ma'am.
What did you say?
A prayer in the EM, my lord.
Not prayer, let's see the affidavit.
Page number 38, my lord. I further submitted the above suit filed for the declaration. They are the absolute owner of his real property. The same has been acquired by my deceased husband Anmantappa through
What is the
party.
purpose of this? I don't understand.
Yes, my lord.
I don't understand the purpose of it. Your evidence is closed.
No, no, my lord, because my
Matter is coming up for argument.
one submission, my lord.
What only with this application
Yes, ma'am.
to call for this document? What will you do?
But I have to prove my case because the entire case depends upon the document that.
What are you doing? What are you doing when your evidence is over? When the evidence
Yes,
is
ma'am.
going on? When were you impeded as in the suit? When you have come on record as LRs?
Last time came on record and I'll also let in evidence. One submission, my lord, because the entire my evidence that my case depend upon that document. Suppose this document is not.
That it all depends upon it. What were you doing? Where what did you say? in
In,
the affidavit?
on the terms it may be, let's make at least one submission, my lord. One submission, my lord.
Yes.
One submission, my lord. At least I may be accommodated for 2 months. I will get it the document from that document.
Be done. Why should it be done now?
Till then, for 2 months, don't precipitate, direct the trial court not to precipitate the matter for 2 months, at least 1 month, my lord, because the entire case depend upon that.
Who stopped you from doing it? Suit is of which year?
10, my lord.
10.
One submission, my lord, because the entire case may depend upon that, partition deed. Suppose the partition is not summoned, or I have not produced by other modes, I will deprive of my case, because my case is that the property has been allotted to the husband.
Court has given you enough opportunity. Why you didn't do it?
Sorry, my lord, because
There is no affidavit. The purpose of affidavit is this. Filing an affidavit along with that IA is this, to tell why you want, to explain to the court why you want this application to be allowed.
because that my case is depend upon that document, that's why.
You have not done it. Why you have not done it? All three. The 2010, we are in 26. 16 years old suit.
Because one submission, because of delay, my entire case has been not aware. Because one submission.
That is how it happened.
Kind accommodate for 1 month. Don't direct them to not to proceed with the matter, because the matter is possible. I may make necessary steps to take.
First of all, for that I should feel that you have that it should be allowed. Then I'll ask them to not to precipitate.
Yes, my lord, at least over that. Not to precipitate.
Dismiss. Next matter.
One submission. Let them direct not to precipitate the matter.
No, dismiss.
Number 9. One name Raju P. of petitioner.
Plaintiff is before my lord. Plaintiff is before my lord.
What is the suit for?
I had filed an IA to calling upon the defendants to produce the original documents which they claim to be in their possession and custody. Suit for declaration of title. My lord, may kindly come to annexure F, page 37. That my IA is allowed. Page 37, annexure F. My lord, the court directs them to produce those documents. My lord, he comes before the court and he files an affidavit telling that the affidavit is at annexure H. He comes and he says, page number 48. He states, I have given the original documents to my vendor. Then I file one more IA, which is the present IA. Direct him to get it from the original.
What is the purpose of this?
The claim is in respect of the defendant's content that this power of attorney under which they claim title and sale, the signature, they claim that I have executed the power of attorney. If these documents are not produced, my lord, I will be unable to.
No, if that GPA, have you, when you're saying that that is not signed by you, and what is the relevance of that to this?
They contend that I have the original power.
What is the suit for declaration?
Suit for declaration of title and to declare that the sale deed alleged to have been executed by me is a nullity. They contend that the original power of what I had given them, a original power of attorney, I had given them the original documents.
Yes, what is the present? Then why do you don't require the sale deed?
Pardon?
You don't require the sale deed that is executed in favor of the subsequent.
No, at least the power of attorney which they claim that I had given to them, that document also they say is in their custody.
Where is that? Let's see what did they say.
Pardon?
Let's read that affidavit that's filed by them.
Kindly come. I affirm that I met my vendor so and so, age so and so in the office and handed over all the original listed in the acknowledgement enclosed. These are the documents. The documents are at annexure D.
No. You're reading where?
I'm reading his affidavit.
Page number?
Page number 48. Annexure H. He says, my lord, all the originals listed in the acknowledgement, he has given it off to his.
In OS number 170 filed by against the plaintiff.
He files the suit.
Party to the proceedings. Clearly known that all the originals were part of the plaint from filing date 30 until the disposal date at 2/11/2023. Never wanted originals during the period of the proceedings.
No, first paragraph. Kindly see first paragraph, previous page. And handed over. I am reading at annexure H, page 48, first paragraph.
Yes.
And I have handed over all the original listed in the acknowledgement and.
That here, that's what. Is this 48? I affirm that I met my vendor.
Yes, my lord. The last line of that sentence, last line of that paragraph, and handed over all the originals listed as per acknowledgement. He says that it is handed over to Shri Prabhavati Chandapur.
Where are there? What are the documents he has given to us?
These documents I have, it is at annexure D, which I have listed out at page 30.
No, you're only concerned with the GPA.
At least the GPA, my lord. Now what the learned judge says is, since he has filed the affidavit.
So why do you want all this? When you're denying the GPA, why do you require all this?
At least the original GPA I need, no, my lord.
That I understand. Why do you want 1 to 16?
1 to
16 documents.
No, my lord, I only want 1 to 3, which I have mentioned at annexure D, my lord. That's all.
Para number?
At in the application annexure D. This is the application, my lord. I don't want all of them. I only want these 3, my lord.
Original registered sale deed.
Yes. Original power of attorney and only these 3 I want. I don't want the other documents. They say that these documents I have executed. I am saying I have not executed. These signatures are not mine.
Registered sale deed in favor of the plaintiff. That is your vendor.
Why my lord, this person, he claims to be my POA and these documents he has usurped to his custody. My case is that he was appointed as a power of attorney holder only to look after these properties. He creates one more power of attorney and
if that is the case, this document should be with you.
No, the original sale deed is with him because at that point of time we were developing the layout. At a given point of time we were good friends, but now we have fallen into bad.
Come to the order. Come to the order.
Yes, my lord. Kindly come to page 14, my lord.
Yes.
My lord, yeah, this is this Nandish, my lord. It is worth to note that here that already C. Nandish has filed affidavits. That is, he refers to that affidavit which I pointed out, that all the original documents are handed over to vendor. The said person has not furnished the address of vendor. Such being facts, it cannot be directed C. Nandish to collect the original documents from his vendor and produce before the court. On the next day also, C. Nandish may come before court. He has not traced out the address of the vendor, or his vendor refused to hand over the under these circumstances, no useful purpose. The court expresses its inability. The court has the powers to do it. Just because he says that it is given to so and so, the court cannot show.
No. First of all, where are the particulars of address of that person?
Well, he says he has given it to his vendor. He must produce. He does not give it. You cannot escape. The court is not helpless.
Please come. Then counsel for the petitioner submits that the court, having appreciated the fact that the originals are handed over to one Prabhavati, who is a vendor of the defendant, has failed to allow the application that is filed with the failed to allow the application that's I number 2 of 2026. It is submitted that just on the ground that defendant has not furnished the details, the address of the vendor, that cannot be the ground for the court to dismiss the application. It is submitted that when the whole case of the plaintiff that he has not executed any GPA, and it is a case of the defendant that the petitioner has executed the GPA, and by virtue of that, that the further sale deeds are executed. Considering the submission, they shall be stay of all further proceedings in so and so. So, issued to the auditor, the hand summons memo to be filed by second, or else stay granted with this court. Stands ready.
Stay for a short period.
Stay is granted.
Cell number 10. MS Chandrasekhar Babu.
Memo is found, but don't give a date. 2nd July.
Cell
Yes,
number 10.
No representation list in the month of August. Yes,
Cell
11.
number 11. Sayed.
The suit for eviction was filed against the petitioners.
For the
and,
caveat respondent, Your Honor.
Filed a recall application. Caveat remedies.
Papers are served.
Papers are served today morning, Your Lordship.
We had served it through mail, but only the advocates one spelling got missing.
I'll take it up tomorrow in the first list.
My lord,
Yes, ma'am.
my humble submission is this is an order challenging the recall application, dismissing the IA for non-filing the written statement within a statutory period of 120 days under Commercial Court Act. It is a settled law, my lordship. The delay of 87 days is there. On the ground of file.
It's on the merits of the matter you're arguing.
Yes.
My lord, I am ready to make submission nonetheless. The petition itself is not maintainable.
Yes.
Please.
We had filed an application for 7 to 11, my lords, because the suit was not maintainable in the Commercial Court Act, because it was related to the residential property, the flat in respect of the residential flat, where we had paid a premium amount of 16 lakh to the defendant number 1, who is respondent number 3 in the writ petition, my lords. So that came to be rejected in 16.
What is the suit for?
Suit for ejectment, my lord. We are the tenants over there, where we had paid 16 sum of premium 16 lakh rupees to the person whom they have authorized. That is the defendant number 1 in the trial court and respondent number 3 here, my lords, namely Tanzanite Reality Brokerage Company, my lords, for which we had filed an application on 7 to 11, stating that the suit was not maintainable, which came to be rejected. And immediately we filed an application for recall and permission to file WS in 16/3/2026, my lord. The suit was filed in 2025, and we had filed a wakalat on 10/9/2025. There was delay of 180 days, my lords, and the reason was she is a single lady, a divorcee, and staying with her mother, and her mother was suffering from age-old ailments, and she had to obtain the documents, my lord, because certain transactions were done to their account as well, and the suit for injunction was also filed. She had to obtain the documents. That was the main reason why we had delayed for the WS, my lords.
Come to that.
That is in page number 30, my lords.
Page number?
30, my lords. Both advocates are present. Defendant number 1, 2, written statement along with IA number 3, 18 Rule 17 CPC number 4 to recall, reopen previous stage and permit to file written statement. On 9/8/2025, suit summons have been served upon the defendant number 1. 10/9/2025, they appeared before the court, Sri SN Council, the statutory time limits of 120 days.
Where are you reading? Page 29.
30, my lord, this is 30. Reopen the previous stage and permit to file written.
What is the IA? That's why I'm reading before page.
My lord.
Was filed under order 17 rule 1 seeking 20 days time for.
That is in page number 53, my lords. In para number 3 of 54, in para number 3 of my affidavit, I submit that the above case is posted for written statement. My mother is aged about 49 years and having health issues, been suffering from quite long duration due to the bad health. Hence, I am unable to attend the court on regular basis.
So, you have not filed the written statement?
Yes, my lords.
And that is that. No, you don't want to file the written statement.
I want to file, my lords. We had challenged 7 to 11 on the maintainability of the suit itself, my lords. That was the reason why it was posted for orders on 16/3. Immediately filed a recall application to permit me to file WS, my lords. I have not even gotten a single opportunity, my lords, to produce my document.
When was the summons served on you?
My lords, that was on 10/9/2000. That too through council was appearing to the council. 10/9/2025, my lords. I had filed a wakalat. 10/9/2025. So on 19/9/2025, I filed an application for 7 to 11, my lords, on maintainability of suit. And 9/2/2026, that came to be rejected, my lords. Then on 5/3/2026, we filed an adjournment application that we need some time to obtain the documents. Even on the same day, adjournment application also came to be rejected. Then on 16/3.
So you're only on this order, that is at dated 5/3/2026.
Yes, my lords.
That is with regard to the written statement. As you have not filed the written statement, you cannot lead the evidence.
Yes, my lords.
What is wrong with this order?
My lords.
What is wrong with this order?
My lords, I have not got an opportunity to file a written statement, my lords. I may be, my lords.
Why you cannot file a written statement? What opportunity you require?
To file the written statement, my lords.
That's what is that opportunity you require? You have entered appearance on so and so date. Within so and so time.
We had to obtain the documents, my lords. That is the bank transactions of the defendants as well.
There is a timeline fixed under the act when you have to file the written statement.
One opportunity may be given, my lords, or else my premium amount of 16 lakhs will get forfeited, my lords.
My lord, my short submission is the statutory provision with respect to filing of written statement is clearly stipulated in Order 8 Rule 1 and Order 8 Rule 10 of the Commercial Court Act, amendment to the CPC. And also this has been it is now 8 Rule 1 and 8 Rule 10, amendment to CPC through Commercial Court Act.
Give the judgment. It must have been,
I will pass the judgment on the point.
take that.
My lord, the first judgment is SCG contracts versus KS Chamankar infrastructure. This is the Supreme Court ruling of 2019. This is the settled law, my lord, on the point of period of prescribed for filing the written statement. My lord, the relevant portion is here also in the similar circumstances, there was an
Where
application.
is that? First we read it.
Please. Para number 8, the operative portion is at page number 4, my lord. Para number 8, page number 4, operative portion.
No.
My lord, may I read?
Judgment is SGC contract.
SCG contract.
Yes.
My lord.
Para number?
Para number 8, my lord.
Yes.
May I read?
The commercial court.
The Commercial Court Act, Commercial Division and Commercial Appellate Division of the High Court Act 2015 came into effect from so and so. The certain in wake of amendments to CPC. In Order 5, Rule 1, Sub Rule 1 for the second proviso, the following provisions shall be substituted. Provided further that where the defendant fails to file written statement within the set period of 30 days, he shall be allowed to file the written statement on such other days as may be specified by the court for the reasons recorded in writing on payment of such costs as the court may deem fit, but which shall not be later than 120 days from the date of service of summons, and on the expiry of 120 days from the date of service of the summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. Further, equally, Order 8 Rule 1, a new proviso was substituted as follows. Provided that where the defendant fails to file written statement within the set period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for the reasons to be recorded in writing and on payment of such cost as the court may deem fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file written statement, and the court shall not allow the written statement to be taken on record. This is re-emphasized by reinserting yet another provision of Order 8 Rule 10 CPC, which reads as follows. Procedure when the party fails to present the written statement called by the court, where any party from whom a written statement is required under Order 1, under Rule 1 or Rule 9 fails to present the same within the time prescribed or fixed by the court, as the case may be, the court shall pronounce the judgment against him or make such order in relation to the suit as it may thinks fit, and pronouncement of judgment, a decree shall be drawn up. Provided further that no court shall make an order to extend the time provided under Rule 1 of this order for filing the written statement. A perusal of this provision would show that the ordinarily written statement.
It is understood. 120.
My lord, even in this, the facts are also very similar. They had also filed a application for rejection of the plaint, and that comes to be dismissed. Subsequently, they file an application seeking permission of the court to file the written statement under Section 151, invoking inherent power. That has also been considered by the Honorable Supreme Court, which says that the inherent powers of the court cannot be invoked where there is a statutory power.
Yes.
My lord, I have also passed the coordinate bench ruling on the same point. Yes. That is Messrs. Image Technology. This is 2025 ruling, my lord, versus Messrs. Granite Industries. My lord, the relevant para is at page 7, my lord, para number 9.
Yes.
The application is filed under Order 8 Rule 1 read with section so and so. Para number 9, my lord, page 7.
I think we don't have to go into all that.
Please.
You can come straight away to paragraph number 12.
10 is the relevant para, my lord. The summons in the case at hand was admittedly served on the petitioner on 17/2/2024. The petitioners appear before the court on 16/3/24, and the learned counsel for the defendant sought time to file written statement on 3/4/24, but filed it only on 4/7/24, long after a period of 120 days is over. The written statement is sought to be filed along with the counterclaim on the 137th day from the date of service of summons and 17 days from the date of expiry of 120 days.
Yes.
Therefore, viewed from any angle, there is a delay in filing the written statement.
Yes.
The statute, my lord, in this case, there is a delay of 87 days from the date of service of summons, which is clearly returned and detailed in the order sheet. It was served on 9/8/2025, whereas their application seeking recall and reopen is in the month of March 2026, my lord. Hence, there is no merit. It may be dismissed.
120 plus 80 days, you're saying?
No, totally 120 days, my lord. Delay is 120 plus 87
It
days.
is 180 days, my lords. Total is 180 days. My lords, my rights will be detained, my lords. I won't be able to establish my rights, my lords.
Rights will be denied when the provision is so specific.
But my lords, there was only one reason was on why we had to file an application for 7 to 11.
There's no discretion.
Yes, my lords.
There's no discretion.
But I won't be able to establish my case at all, my lords.
What to do?
One fair opportunity may be given for me, or else no injury will be caused to them, my lords.
Be given. How can it be given?
At least on cost, it may be imposed, my lords, and one opportunity and speedy disposal also may be allowed for them, my lords. We have no objection, but the contention here is, my lords, the defendant number 1 is placed as ex parte. 16 lakhs we have paid, my lords.
Yes. Yes, Mr. Next.
Cell number 12. Nitin, Madam,
The petitioner.
To the file.
My lord, defendant's petition, my lord. This is arising out of refusal of the first appellate court, my lord, in my regular appeal to grant an interim injunction in my favor. My lord, the petitioner was the defendant in the suit. Petitioner is the church, my lord. The property, my lord, the problem is
You are the defendant in the suit.
I am the defendant in the
Suit
suit.
for
Suit for
injunction.
permanent injunction is decreed.
Uh,
Decreed against the true owner, my lord, unfortunately. He says, the property, the plaintiff says,
What are they?
property is survey number 55/1A3. But my lord, in 19,
What did the trial court do and what did the appellate court do?
my lord, appellate court now
Granted injunction.
did not grant me an injunction. I was the defendant in the suit, my lord. Suit was decreed. I filed the regular appeal.
Oh, in
Before
that you
the-
filed.
In that, I had sought for not at least an order of status quo, because this honorable court in an earlier writ petition in the same matter, my lord, said because there is a dispute as to whether these two
Please
properties.
come to the order, the judgment and decree in OS.
My lord, OS, I have not. The lordship may
Don't
permit
file
me
these
to.
many documents,
My
but
lord,
not
that
file
is
the
gone.
documents which are relevant.
My lord, the bulk is because there is a memo filed in the appellate court. My lord, that memo is the bulk. My lord, before this, just one sentence, my lord, 1 or 2 sentences. He
The
says
suit
the
for injunction is
suit for injunction is decreed. He says it is survey number 55/1A3. In fact, my lord, we are both claiming under the same person that he.
What is the finding of the court?
Yes. Now, your lordship may take internal page 14, minute 14 of the, just before coming to the finding, para
Yes.
21 minute.
Mm.
Upon perusal of the material record, it is not in dispute that the suit property was originally purchased by Leslie Mitchell and Hannah Mitchell under registered sale deed dated 4/4/19.
Who are they?
They are my lord, they bequeath the property to the church. He says now.
No, let's read.
Yes. My lord, then rest of it we can skip. Then the finding, my lord.
26. On appreciation of the above documents.
Yes, my lord, that there is lot of, yes, 26. On appreciation of the above documents, it is evident that the revenue records initially stood in the name of Hannah Mitchell, thereafter in the name of Sundar Raj.
Sundar Raj is the
Sundar Raj is the purported vendor of the plaintiff. And subsequently, the plaintiff acquired the property.
When the revenue records are in the name of Sundar Raj, from which year?
2020, my lord. My lord,
2000?
what happens was, the revenue department, unfortunately, despite the land having been converted, continues the revenue entries, my lord. The RTCs are continued. That is what is now taken
The
advantage of.
Sundar Raj is paying the taxes as per the court.
I am paying, my lord, to BBMP.
That's
The RTC stands in his name. Yeah,
No, no,
I'll,
no.
my lord,
It
I'll
says
explain what happened.
The plaintiff name has also been entered in
Yes.
the municipal records.
Yes.
And he has been paying the taxes.
I am also paying, my lord, because the property is
That he is
reassigned.
taking taxes
Double,
from
my
two
lord.
persons.
Yes, my lord. I'll explain what has happened.
No, we'll read, we'll
Yes.
complete this.
The plaintiff's name has been entered in the municipal records and he has been paying taxes. The defendant contends the suit property and Sunbeam Cottage are one and the same, and Hannah Mitchell had bequeathed the property to defendant trust under a will, pursuant to which probate was obtained. It is also contended that the property has been converted from agricultural to non-agricultural use during her lifetime. Exhibit D1 is the judgment and decree in OS 660 of 2004 dated so and so, which shows that the defendant had filed an eviction suit against Sundar Raj, plaintiff's vendor, in respect to the portion of property in Sunbeam Cottage. The suit is dismissed. Exhibit D4 shows that Leslie Mitchell had relinquished his share. I'm not just pausing for a moment. This Sundar Raj in that suit sets up a counterclaim for adverse possession of the very same property. And now he says they are different properties. Exhibit D5 to D7 are documents relating to alleged conversion of land from agricultural to non-agricultural use. However, these documents do not bear proper official seals and the plaintiff has disputed their authenticity. Defendant has not proved these documents in accordance with law by examining the concerned officials and are producing certified copies. Therefore, these documents cannot be safely relied upon to conclude.
What
that
is the case of the defendant?
when a defendant is claiming through the same Hannah Mitchell, it was bequeathed.
What, there is a sale deed in favor of.
There's a probate, there's a will, which has been probated, and there is a transfer deed. Probate is
Both of you are claiming on the same, the will executed by.
No. He does not claim under the will.
That is what I'm asking.
Now what he
about him.
does, yes, now what Sundar Raj does is, he says, I was the grandson of Hannah Mitchell. Property has devolved on me by intestate succession. And Melody, he gets the RTC changed in his
Then
name.
what about, is it the fact that he is the grandson?
No, Manoj, because in that earlier suit where he claimed adverse possession, he says my family came into the property as servants in a portion.
Where is that suit?
OS 660 of 2004, that is on record. That judgment is on record in volume 2, page 461. And in that suit, if your lordship would see, I have given this property number 86.
Come to the appellate court.
Yes, appellate court, Manoj, there are no reasons. Page 29, annexure A.
20?
The order is at page 31. Page 30, bottom, Manoj, 15/5/2026 is the date of the order. Page 31. Page 31, may I read now? Appellant has filed, this is for the vacation filing, heard and perused the records, it is submitted that there is urgency, IA number 1 is allowed. Appellant has preferred the appeal challenging the judgment and decree.
Agreed with
But may I just point out one fact. This honorable court had granted us.
I'm granting
yes,
an interim order.
I'm grateful.
The petitioner, who is the defendant in the suit, has preferred RA number. What is the number?
47.
Now it is RA 5, now renumbered as RA 47.
RA 47 of 2026. And along with the appeal, he has filed an IA seeking injunction restraining the defendants from restraining the respondent plaintiff from interfering with the portion of the claim of the petitioner appellant that came to be dismissed by the court, observing that the petitioner could not make out the prima facie case. Then counsel for the petitioner has drawn the attention of this court to the judgment and decree passed by the court. It is submitted that this property is bequeathed to the church in favor of the church by the owner of the said property, and the plaintiff, in fact, as earlier has filed a suit, and therein he has claimed that he is a servant and in occupation of the property and perfected title by adverse possession. Now,
Plaintiff's vendor.
Huh?
Plaintiff's vendor claimed to be the same.
Plaintiff's vendor, and now the plaintiff has come up with altogether a different version. It is submitted that they are in possession of the property, and there is a church in that.
No, he demolished that cottage also when that injunction was granted. That is not there.
It is submitted that if the court order granted injunction, considering the submission and counsel of the petitioner and balancing the interests of both the parties. This court deems it appropriate to direct the parties to maintain status quo. Notice to the respondent, petitioner is permitted to take out hands on this.
Status quo as to the petition scheduled property. I have
Status
described
quo
in
in
the
respect
schedule.
of the property. In respect of the suit scheduled property.
Minute, suit is described differently. The number is varying, minute. That is the problem.
How can you file a?
I have given both numbers. I have given both numbers.
It can be only of you are against the judgment passed against that you are in appeal. How can there be different property in the appeal?
No, minute. It's the same property.
Whatever it is, as per the suit scheduled property. Yes.
Then number 13, CS Madhu.
Yes.
Defendant number 1 in the OS, my lords. May I request your lordship to peruse
The
suit for partition and separate possession, my lords.
This is IA.
IA is filed under Order 7, Rule 11A and D, my lords. May I request your lordship to peruse page number 37. Memorandum of plaint, and the plaint was filed by
the order.
But the order is at page number 100, my lords. No order has been passed on Order 7, Rule 11A and C, my lords. The court has proceeded to pass orders on other IAs. My IA was filed on 8/10/2025, my lords. That IA was not at all considered, my lords.
How can you question it? What is there to question in this?
May I request your lordship to peruse page number 37, my lords?
No, I'm looking at 100.
Please, my lords. I am not challenging any order, my lords. I am just seeking the writ of mandamus, directing the trial court to dispose of
When was
Order
your
7.
IA filed?
IA was filed on 8/10/2025, my lords.
Please come. The present petition is filed. Seek a mandamus directing the trial court to dispose of the pending IA number.
IA number 7, my lords.
IA number 7 filed under order 7 to 11 in a time bound manner. It is submitted that the case is the IA is filed on 19/9/2025.
Please, my lords.
Considering the fact that the IA is filed on 19/9/2025. This court deems it appropriate to pass following order. So and so is requested to dispose of I number 2.
7, my lords.
7 filed under order 7 to 11 within a period of 2 months from the date of receipt of the copy of the order.
Grateful, my lords.
14, Sunil Kumar H.
Yes.
Please. Appeal for the petitioner.
Yes.
I was the defendant before the trial court, my lord. The only ground is that, my lord, the written statement was not filed by me within the maximum period of 120 days. It was only 15 days more. It was a delay of 15 days. The learned judge.
No, there is no discretion to condone.
Yes,
Now, there are certain petitions which are filed questioning the amendment itself. Unless
That has been stayed, my lord. This honorable court has stayed the
you
entire
have to
amendment.
question it.
That I also have mentioned it. But similarly, the coordinate bench also have taken a ground. There's also the judgment I'll bring to lordship's notice, my lord, that since if there is a minor delay of 15 or 20 days, a discretion is always there to the learned judge, that he can see there's a genuine grievance, then he can just still condone it. My delay is only 15 days.
Court says shall not. That means there is no discretion.
But
Court
that
may condone the delay if the other coordinate bench says show the judgment. If I want to differ on that, we can defer it to the, because there are these matters are pending consideration.
Please, ma'am. Similarly, ma'am, one judge, please.
Take that. Whether the amendment is brought to the notice of the court.
It was brought, my lord, during the course of hearing. But only thing I'll only take only last paragraph where lordship only mentions. I'll only request lordship to kindly come to page 13, my lord, 1-3. Only 2 paragraphs on the discretion. The coordinate bench says. Page 13, my lord, para 10. Consequently, the defendant was served on 10/5/2018. The written statement was filed shortly thereafter. The reasons are set forth for delays that the defendant did not have all the documents available with him and took some time.
We'll refer it to a. Well, we can't. This is not the correct law. Because
I respectfully agree with what Lordship says, but now one bench has said discretion is there.
we'll refer it. That can't be. We can't perpetuate the.
But now the amendment which was brought in, my lord, 120 days maximum, as Lordship rightly said, shall, it is stayed by one more bench. Now, in that view of the matter,
Where is
please, my lord, that interim order is also there. That amendment itself is stayed, which imposes a condition upon the lower courts not to condone the delay at all. That itself is stayed. Kindly come to the next page, my lord.
Where do you get that? That amendment is stayed?
Please, but next page, my lord, last line, 8, it begins with, accordingly it is ordered as follows. There shall be an interim stay of the operation and implementation of section 4 of the CPC amendment, insofar as it introduces the third provision to order 5 rule 1 of CPC, mandating forfeiture of the right to file written statement beyond 120 days. Consequently, the trial court shall, pending further orders, exercise discretion in receiving written statements beyond 120 days in accordance with the law laid down by the Honorable Supreme Court in Salem Bar Association, Tamil Nadu versus Union of India, and so on, binding precedents. It is made clear that such discretion shall be exercised judiciously and for the reasons to be recorded in writing, and so on. Even in my case, the learned trial judge also mentions that just because there's an amendment which bars me from exercising discretion, I cannot do that.
He was right. He was right.
He's right, my lord. I don't dispute that. But since, my lord, there are two views here, and very amendment is stayed, then he should have exercised discretion. That lordship may say. That is, let him exercise his discretion.
So, unless and until we decide this, there can't be a stay on this. It would create a lot of chaos. Half of the matter, and even the district judiciary also, they'll be completely left with what to do.
Only those matters, my lord, where the minimum delay, they come to court. Let them show discretion. I'm not telling if there's extraordinary delay, 100 days.
Not on that point. The discretion is there. Discretion will be exercised judiciously.
So
there is an amendment to the act.
And that amendment is stayed. Now, the learned judges are free. They can exercise. They can't say that there is an amendment, I can't do that. Amendment itself is stayed. That being the case, he can't wash off his hands. If there's a genuine case, a defendant is prevented.
When is it coming? The future, when is it coming?
Please, my lord.
When is this matter coming?
This matter, my lord, as my instructions are that it's on 18th, 17th or 18th, it's there.
In counsel for the petition submits that a coordinate bench of this court had stayed the operation and implementation of section 4 of the Code of Civil Procedure insofar as it introduced the third proviso to order 5 rule 1 CPC mandating forfeiture of the right to file written statement beyond 120 days and directed the trial court to consider the same on the merits of it. And the said writ petition is pending consideration. The petition has also drawn the attention of this court to WP number 12037 of 2021, dated 24th February 2026, wherein the coordinate bench has directed the court to directed the trial court to take the written statement on record as the delay is not inordinate. The act, the amendment to the act specifically says that it shall be filed when a word shall is used. there is no room left for discretion to the court. Hence, court cannot, and hence this court is not able to accept the view taken in WP number 12037 of 2021, which is contrary to the settled law. The similar provisions are also there in the Commercial Codes Act, and the Honorable Apex Court has upheld the same. And this judgment is contrary to the judgments of the Supreme Court. Then coming to the order, as the coordinate bench has stated, the operation of the act itself, there shall be stay of all further proceedings.
Please.
Notice to the respondents.
Grateful, grateful.
Petition is permitted to take out hand summons. Yes.
Cell number
And
15.
I'll file a memo to the defect by second.
I am for the petitioner, ma'am. Kindly short pass over me.
In all this, always when I say notice hand summonses, hand summons to the council appearing for this form for the trial. Yes.
Serial number 15. Kindly short pass over me.
Pass over
Senior is engaged in another court matter. Kindly short pass over me.
this matter next week.
Next week.
Yes.
Cell number 16.
For the petition, kindly have it in the next week, my lord.
Shankara Gowda.
This is matter in the month of June. Yeah, in the month of August. Yes, 17.
Cell number 17. PN Harish.
Yes.
Plaintiff's petition will not suit for eviction of the respondent, that is who is the tenant under me. In the proceedings, my lord, I filed an application in IA number 1 under section 151 to direct the defendant to pay the rents from the date of suit, not for any other things. That application came to be rejected.
See that.
Please. Lord, page number, my lord, it starts with page number 34, my lord.
Yes.
And these are all the pleadings.
What is the case of the defendant?
Pardon? Case of the defendant in Milad, he admits he is a tenant. There is no dispute about the dual relationship. Kindly see, Milad.
And what he disputes with
That
regard
is-
to the amount of rent?
That is also not in dispute. He says, I am saying that 50,000. He is saying that 40,000. At least the 40,000, this should have been a direction. I will just refer to that, Milad. Kindly see is the statement of objection.
This
Pardon?
order.
Pardon?
We'll
Please,
continue
please,
reading
please.
this order.
Milad, the order portion is the page number 34, Milad. And the reasoning, Milad, starts with para number. These are the pleadings of the parties. Reasons at point number 7, that is page number 37. And the relevant portion is a short order, Milad. Para 12 of the order, at page number 39. The learned judge says that there is a dispute. On carefully, may I just read?
Para 4.
Further contended in the said scheduled boundary, entire building was given and it is in possession and enjoyment of the said building. This fact is and was within the knowledge of the plaintiff. The defendant has been enjoying the said property building up to that date, that is on 3/10/2024. The plaintiff came near the scheduled property, wanted to see second floor by taking the key from the defendant, and later she and her husband illegally bring some luggage and they not handed over the key to the defendant and continued in the second floor illegally, and for the said reason the defendant required the plaintiff to vacate the delivered possession of the said portion, but they have refused to hand over the said second floor building and started Galata on 4/10/2024, and the defendant lodged a complaint against the plaintiff and the supporter and criminal case was registered against him. The plaintiff also filed a complaint against this.
That property comprises of how many floors?
Milad, it complaint of 3 floors, Milad.
So
The
for
entire
3
it is in-
floors, for the 3 floors, according to you, the rent is 50,000. According to him, it is 40,000.
Yes.
Now, according to him, you have taken the keys of the second floor
No,
and
no.
locked it. That's his
Please,
case. That's his case.
that is true, Milad, but he says that he has not been able, we are trying to do it.
No, no, no.
No, kindly see, the return statement it is
He
clear.
paid
I
the
will
rent
just
of
refer to
20,000.
the return statement. The,
Suppress the fact that and file the suit. Does the defendant pay the rent of 40,000 to the plaintiff if he vacates the second floor and deliver possession to the defendant?
No,
Then he
that
will
is-
pay you the 40,000 rent.
Milord, kindly see the written statement. Written statement, Milord. In the written statement, no such pleadings at all.
The defendant has filed objections by denying the claim of arrears of rent. The
that
defendant
is that-
asserted that no rent is due and payable, and the plaintiff claim is false, frivolous, vexatious.
Sir, kindly see the objection statement that is filed by the defendant. Milord. Page number 29, annexure E. Para 5. He admits it.
12, please come to paragraph number 12.
Paragraph number
12.
12 of the objection statement.
No.
Order.
Of the impugn order.
Please. On carefully peruse the pleadings, the application objection filed by defendant and the documents on record, it is evident that the claim of arrears of rent is seriously disputed by the defendant. The plaintiff has not produced any concrete evidence or any acknowledgement from the defendant to establish the existence of arrears. The court finds that the dispute regarding arrears of rent is factual issue that requires evidence to be led by both the parties during the trial. At this stage, the plaintiff has failed to make out prima facie case for the grant of interim relief. In view of the above, the plaintiff has not made out any grounds to allow the application. Milord, I am seeking for an admitted rents at least, because he admits it to be, I am paying 40,000 rupees for.
You say admitted rents, that means not arrears. From
From the
now
date,
on.
kindly see the application, Milord. From the date of suit, I am claiming. Application, kindly.
When the suit is filed.
Suit is filed in there on Milord.
Let him come, then we can consider your case. The notice to the respondents, petition is permitted to take out hand summons. If the memo is filed by 6th of July, list is marked on 7th
Handsome, Milord.
to the counsel appearing for the respondent.
Or
Yes.
both to this.
Respondents.
Case number 18. Prasad K for petitioner.
For petitioner in this case, your lordship, this is a suit for partition. Plaintiff has filed 3 applications, your lordship. One is for amendment and the other 2 is for impleadment. And the fifth defendant has filed an application for recalling the order to file his written statement. Common order has been passed on all the 4 applications, dismissing all the 3 applications of the plaintiff and allowing the application of the defendant. My lord, the present petition is with respect to IA number 11 under order 1 rule 10, your lordship. I have filed other 2 writ petitions, my lord. It's listed today itself in the 3rd list, cell number 49, your lordship. 2 writ petitions day before yesterday.
If there is no urgency, we'll take it up along with that whenever it reaches.
There is an urgency. Lords permit me to argue on all the 3 applications. I'm ready to answer.
You argue on this, whatever is listed today. Yes.
My lords, it's a suit for partition. The plaintiff has filed suit for partition herein. The lordship, he has filed an application. One is for amendment, my lords.
So now what is in this? It is order 1 rule 10.
Please, your lordship. This
That
1
you
rule
argue.
10 application is that one other property is not the subject matter of the suit, my lords. E-scheduled property. It has been stated by the first defendant father that one more item is not being included as a suit scheduled property, which the plaintiff wanted to include that e-scheduled property as one of the property to be included after the scheduled property or lordship. This particular property have been purchased in the name of the 6th defendant brother. He has sold it during the pendency of the suit in respect of this proposed defendant number 10, your lordship, wherein he is proper and necessary party to this suit. Therefore,
No, that property is already included.
no, my lord. That is also in the present impleading application and
First of all,
the
that
amendment
we-
application, my lord.
That amendment has to be allowed first.
Please, your lordship. The honorable
That
court-
amendment is dismissed.
Please, your lordship.
On the ground?
On the ground saying that.
So these are all interconnected. Now we can't hear this alone.
Please, your lordship. That's my
What is urgency now?
My lords, the matter now, my lord, here is where the case in this partition suit trial is not yet commenced, your lordship. My lord,
List along with so and so numbers in the third
still
list.
number 49, my lords. Today it's listed in third
Third
list.
list on 17th in the first list. Yes.
Grateful.
19.
Detail number 19.
For petitioners. There's a defendant number 10, writ petition in a suit for specific performance.
Yes.
It's a plaintiff, my lord, respondent filed an application to amend the plain in a specific
You are the
person.
defendant in a suit for specific purpose.
Defendant number 10, my lord, is subsequent purchase and recently added. My lord, in the amendment, my lord, they want to challenge my subsequent sale deed, my lord, I have no much dispute. But my lord, after 18 years, he wants to seek alternative relief of refund. My lord, directing all the defendants, my lord, not from the person who has he took. My defendant number 1, my lord, is the agreement holder. My lord, he received 8 lakhs. My lord, the entire agreement is disputed, but it's on merits. But 8 lakhs is the part sale considered, advance sale consideration amount. No, my lord, as an alternative relief, my lord, he asked 8 lakhs to be paid by everyone. My lord. Agree, my lord, that's the one, my lord, we objected.
No, if the sale deed is, if suit for special performance is ordered,
No, sir, if it is ordinarily, everything is goes. Well, alternative relief, my lord, after 18 years he has sought. Well, annexure D, my lord, pays.
sir, how many are the purchases?
Well, there are 2 purchasers. My lord. I'm the recent.
What is the amount?
So 8 lakhs is the part sale consideration amount. Well, he wants that to be refunded. But let him ask on the defendant number 1, well, that's all.
Let's see. Notice to the respondent and summons. If the memo is filed by 7th of July and list the matter on 8th.
Just press for the process.
Till number 20. 20.
Hearing for respondent 1 to 4, my lords. In this matter, morning I'm instructed to appear in this matter and led by senior counsel, my lords. I request the matter may be taken up on Monday, my lords. I've requested the advocate on record, senior counsel may not be aware now, but morning had been called them and then informed.
Shortest date possible because shortest possible date.
Monday.
This is a matter on Tuesday in the first list.
Please, my lords. Much
Please.
obliged.
Yes, 21.
Till number 21. 21. Manjunatha Vonsley.
You appear for whom?
I'm a counsel for plaintiff, ma'am.
Petitioner.
Yes, ma'am.
Yes.
During the course of the day, the complaint will be made, ma'am. The matter is urgency, praising for a short date, ma'am.
Which one?
Till number 21.
Yes, ma'am. Manjunath Rao Bhonsle.
Manjunatha Vonsley. Petition.
You can argue. There are no objections.
The complaint will be made. During the course of the day, the complaint will be made.
There to be complained. Blanks at oath commissioner seal
Annexure D.
not filed. The office objection shall be complied with. This is matter on 18th.
Till number 22.
Please.
18th in the first list. Yes, 22.
Swaroop S for petitioner.
Just for a password, my lord, senior advocate is on his legs in other court. I've instructed him.
You are taking a chance. If my time permits, I will call. Otherwise, I will not.
I
call.
understand.
Yes, pass over.
Till number 23. KV Narasimhan.
Petitioner, short pass over minutes.
For you also, same. If my time permits, I'll call. If I don't call, these matters will go to the third list. Yes.
Till number
Pass over.
24. Hiramat CS.
No representation. This is matter in the month of August. It's
Till number
25.
25.
This
20.
also.
Till number 26.
No
Admission.
representation. No representation list in the month of August. It's
Proceeding
26.
number 26, my lords.
Yes.
I appear for the petitioners. My lord, senior is hospitalized, my lords. Next week, any date will be fixed, my lords. And there's
The
little
matter
translation required in this matter.
Matter on 22nd.
Please, my lords.
Yes.
Till number 27.
I appear for the petitioner matters. It's a suit for recovery. The petitioner is the respondent number 1. And the petitioner is the defendant number 1 in the trial court matters. Respondent number 1 is the plaintiff. Respondent number 2 is the defendant number 2. The impugned judgment in the page number 9, my lord.
No, what is this?
It's a suit for recovery. Yeah, the seek for 2 lakhs recovery, my lordship. The case is that the plaintiff is a.
Oh, small causes.
Please, here.
What is the amount?
2 lakhs here.
So how much you're going to pay?
My lordship, one small submission here, my lordship. There's 2 different.
Money. It's a decree for money. You
Because
can't, anything we have to interfere,
the
it's
entire
only on
case
condition.
is a small, I'll be paying my lordship. On small submissions, the entire case is the plaintiff has lent the money to defendant number
We will
2.
see only when they enter appearance and when hearing
Please.
it. money decreed will always be 50% of the amount. The petition is agreed with her.
At least
Judgment
30%.
and decree passed in SC number 1078 of 2024, dated 8th January 2026, whereby the court had directed the petitioner to pay an amount of rupees 2 lakhs with interest.
Joint liability. Joint liability. Petitioner and the respondent number 2.
The plaintiff is entitled to recover a sum of 2 lakhs with interest.
From the defendants, my lord.
From the date of, till the date of, yes.
There are two defendants here. I'm representing only defendant number 1.
They're liable to pay the amount with interest to the plaintiff.
Please, sir.
Where is the court says equally?
Defendants, the order like the defendants are liable to pay
That's what.
the decreed amount.
So it is a joint and several liability.
Please, sir.
The plaintiff, the suit is decreed, holding that the plaintiff is entitled to recover a sum of rupees 2 lakhs with interest at 6% per annum from the date of petition to the date of realization. The petitioner before this court is defendant number
1, madam.
Defendant number 1. Considering the submission, there shall be stay of further proceedings. As far as the petitioner defendant is concerned,
Please.
the defendant 1 and 2 are related.
The 1 and 2 are related, but the entire loan is taken by defendant number 2. The entire case is that he has lent the money to defendant.
What is the relationship between 1 and 2?
1 and 2 are friends, my lord. They're friends.
You have come to the court defendant, as far as defendant number 1 is
But
concerned.
defendant 1 and the plaintiff are close together. Defendant 1 on the court, defendant.
Whatever it is, you have come before the court, I'll grant stay only as far as you are concerned.
Please, sir.
There shall be stay of all further proceedings pursuant to the judgment decreed so and so. As far as the petition number 1 is concerned, on condition that he shall deposit an amount of rupees 75,000 within a period of 4 weeks. Notice to issue notice to respond.
Till number 28.
Oblige.
Yes.
28.
My lord, the file has to be sent back to scrutiny, my lord. The wrong impugned order has been annexed, which was passed on the same date.
This is matter after 2 weeks.
My lord, scrutiny, my lord. Please let it be sent to scrutiny. The document needs to be exchanged.
It will go to the scrutiny there, whatever you want to do.
Lordships may not say 2 weeks, my lord. There's some urgency. I will.
If there's some urgency, why did you file like that?
My lord,
It's a
even the
matter of-
scrutiny did not raise the objection.
After a week. They are also busy with all your work.
Yes, my lord. Certainly, it was oversight.
Till number 29.
Great.
Yes, 30.
29.
Yes, 29.
Ravindra.
Respondent in this case.
No representation for the petitioner. The list is marked in the month of August. Yes, 30.
Till number 30.
Beg to assist on behalf of the petitioner in this matter, my lords.
Take
I'm the
up
defendant before the trial court. My application under 7 Rule 11 has been dismissed. Challenging the same, my lords, I am before your lordships. My lords, I'll just pass on the list of dates, my lords. I'll not trouble your lordships with the document. Just prepared one more.
What is the suit for?
My lords, they are challenging a gift deed of 2012. I'll just, my lords, give your lordships in 3 sentences the background. 2021, my lords, is my sale deed. My erstwhile owner's sister would come to me and say that, look, I also have a share in this property. Kindly help me.
So what is the suit for?
Suit for declaration that the gift deed that was executed in favor of my erstwhile seller in 2012 is null and void.
Who is the plaintiff?
Plaintiff is the sister of my, the daughter of the sister of my erstwhile seller. Well, it's virtually like an extortion suit. Which is why, my lords, three facts.
What is that?
Daughter of the sister of my erstwhile owner. Virtually, my lord, the sister, my lord, has set up her daughter.
Uncle has executed. Executed the gift deed in your favor.
Yes. So my uncle has executed, my lord, sale deed in my favor. I have sale deed in my favor. His gift deed that his father had executed in 2012 is what is, my lords, questioned, my lords, by the plaintiff before the trial court. 2012 was my sale deed, my lords. I would carry out construction activities there. 2025, the mother of the plaintiff.
Let's see, what did the court say?
Court has said it's a mixed question of law and fact.
Let's see.
Please, my lords.
Order it.
Please, my lord, may I persuade your lordships to kindly turn to page number 25, my lords. I'll just point out the relevant paragraphs where the court has answered my contentions. Without dwelling into the facts of the case, my lords.
Yes.
2012, my lords, was the gift deed that was executed. The plaint has been filed in 2025. Absolutely no government has.
In their case, sir, they are not aware of the gift.
No, that is not their case. In fact, the gift deed, my lords, and the subsequent sale deed that was executed, the plaintiff and her mother are the witnesses.
That's why, before going into that, we'll see your affidavit filed in support of the.
Please, my lords. My affidavit lordships will find. Kindly turn to page number 133, my lords. 134 is my affidavit.
Yes.
135 onwards, my lords, I have set out the facts, my lords, which have transpired, which, my lords, I would trace my title from. 3B, my lords. Subsequently, the said late Sitaram conveyed the suit schedule property by way of gift in favor of his son Ramakrishna under registered gift deed dated 2012, registered as so and so. It is a case set up by the plaintiff that B. Sitaram is alleged to have so and so. Out of these joint family funds, the said gift deed could not have been executed. Thereafter, Ramakrishna sold the suit schedule property for a valuable consideration in favor of defendant number 2 by its sale date dated 2021. It is alleged in the plaint that the said sale deed was obtained by fraudulent means and that the said Ramakrishna did not receive any sale consideration. It is not the case of Ramakrishna. Ramakrishna, my lords, has passed away. Subsequently, the defendant number 2 entered into a registered agreement of sale dated so and so, which is registered as so and so. Defendant number 2 and 3, my lords, that are subsequent agreements of sale, and the property has now been constructed. I'll request your lordships to kindly, my lords, have my list of dates that I have prepared, my lords, rather than troubling your lordships with the averments.
No, it is not about the list of dates which you are giving.
My lords.
What is at the plain states? That is what is important.
Very well. My lords, I'll just point out 2 paragraphs in so far as the sale deed is the plaint.
All this you are submitting is in favor of your defense or what your written statement contains.
I vote on.
So you have to show the plaint, and from the plaint how the plaint can be rejected.
Can I pursue your lordships to kindly turn to page number 119, my lords?
Yes.
Please.
Yes.
Whereas the paragraph starts from the previous page 118.
So the suit, what he says, wherefore the plaintiff praises the honorable court and pleased to pass a judgment decree to affect the partition of the plaintiff's estimate, which is seeking partition.
Partition declaration, my lords, first they would say.
The first partition, and then she said to declare the gift deed, which is executed by so and so.
I'll just pursue the lordships to just 2 paragraphs in the plaint.
No, maybe it is a case that the person who has executed the gift deed, that property doesn't belong to him and it is a joint family property.
My lords, he is my own father. He was the father, my lords, of my erstwhile owner. And the subsequent sale deed, my lords, that was executed in my favor.
It is a joint family property. How can the father execute a gift deed in favor?
It is, my lords, it is, my lords, the sale deed that was executed in my favor, the plaintiff herself is a witness to it. Well, let's kindly turn to the sale deed, my lords. Sale deed lordships will find.
Let's see the.
At page number 68.
No, let's see the flags. That will make it clear.
Please.
What is the scope of a petition or 7 rule?
No, I vote on, my lords. The plaint has got to be.
So from the plaint,
Very well. I'll just point out these 2 paragraphs. Very well. My lords, kindly turn to page number 118, my lords. Just 2 paragraphs, my lords.
Yes.
I vote on, my lords. I'm at your lordship's hands. I'll have to demonstrate from the averments of the plaint as to how, my lords, the plaint is unsustainable without getting into the defense that I may have. Just 2 paragraphs from the plaint.
Yes.
My lords would get para number 17, my lords, at page number 118.
Para number 7 or?
Para number 7, I'm sorry, I stand corrected. 7 at page 118. The plaintiff submits that when such being the case, the defendant number 1 has started to mismanage the suit schedule property and she is not providing proper accounts in respect to suit schedule property from last week of so and so. The plaintiff approached the defendant number 1 and demanded her to effectuate partition and put her in the possession. Though the defendant number 1 assured to effectuate partition, she has been postponing the same on one reason or the other, and hence the plaintiff applied for certified copies in respect to suit schedule property and was shocked that though her grandfather Sitaram did not have individual right in so and so or the suit schedule property, he has illegally gifted the suit schedule property in favor of Ramakrishna under registered.
So, she is making out a cause of action on May 2025.
Let's kindly bear with me for 1 minute, my lords. Kindly read the next paragraph. The plaintiff submits that thereafter the said Ramakrishna has illegally sold and conveyed the suit schedule property in favor of defendant number 2 under registered sale deed dated so and so. The copy of the sale deed dated 2011-2021 is herewith produced. Now, my lords, kindly turn to the sale deed, my lords, for a moment.
Where is that?
Sale deed lordships will find at page number 61, my lords. 61, Tane. 61. This was a sale deed that was executed by Ramakrishna in favor of Ramesh.
61.
61, my lords.
What is,
Kindly have page number 68.
what is your name?
My lords, my name is Muthu. I am the subsequent purchaser of the property. Kindly turn to page number 68, my lords.
Ramakrishna is the son of the.
Son of the original owner of the property. Kindly turn to page number 68. Plus the witnesses.
Mohini.
Mohini Sitaram, this Anusha. Anusha is, my lords, the plaintiff before the court. Now, my lords, there is a backdrop, my lords, to this entire case, which is why, my lords, I have prepared the list of dates. What they would do is, I am a person engaged, my lords, in real estate activities. I was constructing, my lords, a property. They would come and ask me for money. I would give them a loan under a loan agreement itself. I would give them 45 lakh rupees.
Please come. Then counsel for the petitioner defendant submits that. Petitioner has filed an application on 7 to 11 to reject the claim. There is no cause of action to the suit, and the suit is barred by limitation. There was this is dated.
My lords.
This is 20th.
The impugned order, my lords. Impugned order.
It is a case of the
4th of
plaintiff
April
that-
26.
It's a case of the plaintiff that the defendant number, when the defendant number 1 has started to mismanage the suit scheduled property, the plaintiff approached the defendant number 1, demanded her to effect the partition. Then she came to know that her grandfather, who did not have individual right, title and interest over the suit scheduled property, has illegally gifted the suit property in favor of his son and registered gift deed dated 3/9/2012. And further, he has sold said Ramakrishna has legally sold the property in favor of defendant number 2 under a registered sale deed dated 20/11/2021. Then counsel for the petitioner submits the plaintiff, both the plaintiffs,
Plaintiff and the defendant number 1.
both the plaintiff and the defendant number 1 are witnesses to the document which is executed by Ramakrishna dated 20/11/2021. And
Sort of stay there.
the case that, and now in the present suit, they're questioning a gift deed dated 3/9/2012 that is very much in the knowledge of the plaintiff, and these aspects were not considered by the court. Considering the submission of the defense counsel, there shall be stay of all further proceeding. Pursuant to the order dated so and so, hand summons on the counsel appearing for the respondent, memo to that effect by 6th of July, or else the stay granted by this court stands vacated.
I'm so deeply obliged.
Number 31, preliminary hearing B group. Rakesh, ME for petitioner.
Complaining to the age of the vehicle.
I request the Sanaba Court, my lord, please to take serial number 32 matter, my lord. In that matter, my lord, the Shardama case is produced.
32.
What are your instructions? Why are they passing these?
That judgment is not applicable, my lord, for the present. That judgment pertains to contract carriage and stage carriage, my lord. This is school bus, my lord, pertaining to the school bus. Moreover, my lord, in this matter, my lord, this notification is not challenged. On the basis of this notification, my lord, that endorsement is issued. May I pass it on, my lord? Statement of objections is very much required in this matter, my lord. Safety of the children, my lord, this notification has been issued.
It is not about the school bus or any other bus.
Please, my lord.
Issue is with regard to this 15
That judgment
years.
is not applicable to the present case, my lord.
Why?
Because, my lord, that judgment is pertaining
You mean
to
to say that it has to be, it is an
stage carriage and the contract carriage.
It is
Further, my lord.
this is pertaining to this 15 years vehicle, whether you have the power to issue such a notification or not. In that case, it is said that you have no power. It is only the central government which can issue notification in this regard.
Yes, my lord.
So you can't distinguish it from a stage carriage, the school bus. It's a vehicle. And what is the power of the state government? That is the issue.
Notification, my lord, section 1C, my lord. Page 6, my lord.
Page
6. This notification, based on this notification, my lord, that endorsement is issued.
You can't give these kind of notifications. That's on a question of law.
Yes, my lord.
What is decided here is it is not about stage carriage or other one.
But
it's a question of law.
but
Whether you have the power State government has a power to issue
But-
such notification.
When the order is passed by the coordinate bench, my lord, this was not brought to the notice of that
No,
honorable
you
court,
have
my lord.
brought it to my notice,
Yes,
but
my
I'm
lord.
saying that you can't apply it that way. It is on a point. It's not about what is the usage of the vehicle. You have no power as per that. And that is not questioned by you.
Yes, my lord. Till today, it is not challenged, my lord. Further, my lord, liberty was granted, my lord.
No, file your objections.
Please, my lord.
I'll,
In both the matters, I will file objections.
I'll grant interim order.
Please.
The petitioners have questioned the endorsement issued by the second respondent. Thereby, what did they say?
Section 1C, my lord.
No.
That endorsement says, my lord, the vehicle has crossed 15 years, my lord. Therefore, the permit cannot be granted, my lord.
No, that is, that renewal of fitness certificate cannot be issued. The coordinate bench of the Dishonorable Court, it is
It is
given in.
submitted that they have issued an endorsement that the renewal of fitness certificate cannot be granted. As that is, as that vehicle is 15 years, more than 15 years old. Land counsel for the petitioner. Where is the judgment?
In the connected matter, it is.
The connected
Next
matter
matter, it
is
is
there.
produced, my lord.
They find
Yes,
the
my lord.
land counsel for the petitioners have relied on
Page 14, my lord, annexure B.
the in case of Srimati Sharadamma in the state of Karnataka and others arising out of WP number 21991 of 2019 and batch dated 20th August 2019. Therein, a coordinate bench of this court has held that.
Circular is quashed, my lord, but circular is quashed, my lord. Operative portion is at page 47. Circular is quashed, but further, my lord, it was the coordinate bench has permitted the state government, my lord, to frame rules.
The
Page 47 is the operative portion.
in the said judgment, it is observed that the state government has issued circular dated 14/2/2019 stipulating conditions. The source of power of state government is established in terms of the provisions. No, not this part, not this part. The court has set aside the endorsement dated 7/3/2019 and dated 24/5/2019 and permitted the state government to frame appropriate rules if it is warranted while invoking subsection 2 of section 72 of the Act. Read with the decision of the Supreme Court in the case of K.M. Ismat Umar versus Regional Transport Authority. It is a submission that thereafter no such rules are framed. Again, like in the in Radhama's case, now the endorsement is issued by the respondents. Learned AGA submits that in that case it's a stage carriage permit, whereas in this case it is a school bus. This court is not able to appreciate the said submission as in the earlier petition, the state circular is set aside and permitted the government to frame the guidelines in that regard. And so far, it is not framed in those circumstances. The order impugned,
Endorsement, my lord.
the endorsement impugned, dated
And there is appeal provision also, my lord. They have to prepare an appeal against this endorsement, my lord. Section 89 is there, my lord.
It is rejected,
Yes,
if
my
it
lord.
is rejected, it's appeal provision.
89 is there,
No,
my
it is only the model of vehicle, designed,
appeal
coordinate bench
provision.
of Dishonorable Court.
no coordinate bench. First, you have to convince me on the merits of
Yes,
it.
ma'am.
Then we will see what
On
the
merit,
coordinate-
on merits is when the law is declared by Dishonorable Court. That is school bus, it's also the public transport vehicle.
89.
You have a right of appeal.
No, my lord, that is for this only insisting model of vehicle, that is not this
It
one.
is a refusal, my lord. Section 89 is clear, my lord. Appeal
And
provision.
what they have said that you produce that the vehicle of less than 15 years. What the endorsement says, we will renew it, we produce with the vehicle of not less than 15 years. Then Dishonorable
They are
Court
also not disputing
considering
it is
this
more
said
than
that
15 years, my lord. They are also not disputing that the vehicle is more than 15 years.
No,
Use
it is
that-
more
use
than
that-
15
use that
years.
Provision.
Please, madam, section 89. Any person aggrieved by the refusal of the state or a regional transport authority to grant a permit or by any condition attached in the
Section
permit.
56 only says all transport
18.
vehicles. They don't say stage carriage, contract carriage or anything. All
89,
transport vehicles.
No.
89
We
is
are on the point, whether the endorsement that is issued, is it appealable or not?
It is an
No,
appealable.
it is not
It is
appealable.
not.
It is appealable. It is a
Why it is
refusal.
not appealable?
Your Lordship, kindly see the 89, section
Yes, I'm
89.
looking at. I'm looking at it.
Please.
Yes. Agreed with the refusal of the state or the regional transport authority to grant a permit or by any conditional attached to a permit granted to him. What did they do now by this order? They said your vehicle is 15 years old. We will not grant you fitness certificate, and they refused to grant you.
It is a fitness certificate. It is a grant of stage
Same.
carrier permit. 89 says. Or variation of condition of permit.
No, where does it say?
Aggrieved by refusal of state or regional transport authority to grant a permit or any condition attached to a permit granted to him.
Fitness certificate is dealt with in which provision?
It's 56, madam.
Yes. Because there should be some finality. In every case, the High Court cannot interfere. There should be a policy, they should follow that.
Certificate of fitness of transport vehicles,
Let's see.
56. 57, next section 57 is appeals.
50? Appeal to whom?
Appeal to the
Any person aggrieved by an
Appellate
order of the
authority.
registering authority under section 56 within 30 days of the
For
date
that
on
also
which
there
he
is
has
an
received
appeal.
notice. Appeal against the order to the prescribed authority.
prescribed
For
authority,
that
but it
also
is
there is an
that
appeal.
we don't come under this one, rejection of fitness certificate.
That's what is the consequences of that endorsement.
Consequence, but what they are insisting 15 years, in view of the judgment, the law declared by this
But you
on
will
court.
tell them, you will tell the authority, appellate authority, why should you rush to the High Court? When there is a provision of appeal and in every matter, why should the High Court interfere?
But
This honorable court
this honorable court consistently interfere even in
It is
fitness.
consistent, whether it is a court was brought to the notice of the court that there is an appeal, then the court said, no, there is an appeal also, we will exercise jurisdiction under 226. Please come. The present petition is filed. Agreed with the endorsement dated. In first matter, agreed with the endorsement dated 5/5/2026, whereby they have refused to grant the fitness certificate as the vehicle is 15 years old. When counsel for the petition submits that it is covered with the judgment of in Radhamma, what is that?
Sharadamma's case, my lord.
Sharadamma's case
In writ petition number 21991 of
is
2019.
covered by the judgment of this court in Sharadamma's case. And
Action.
the coordinate benches of this court have passed several orders directing the respondents to grant the fitness certificate. Leonard HCGP, appearing on behalf of the respondent, submits that Section 56 of the Motor Vehicles Act deals with certificate of fitness of transport vehicles, and Section 57 deals with appeals. Any person aggrieved when an order of the registering authority under Section 56, along with other provisions, even he is aggrieved by an order passed under Section 56, within 30 days of the date on which he has received the notice of such order, appeal against same to the appellate authority. And the appellate authority shall give notice of the appeal to the original authority, and after giving an opportunity, shall pass an order. It is submitted that the petition is having an alternative remedy under Section 56, under Section 57, and without exhausting the same, the petitioner has come before this court. Next paragraph. The petitioner is questioning an order, questioning the refusal, questioning the endorsement, which amounts to refusal of registering the
Only
granting the
with your
fitness
lots of
certificate
conditions.
under section-
Refusal is with reference to the 14/2/2019 notification. It is in a Kannada, annexure D in my writ petition, first writ petition. What they say, ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ದಿನಾಂಕ 14/2/2019 ಅನುಸಾರ, following that 14. When 14/2/2019 is set aside by this honorable court, passed by the
Tell
honorable court.
it to him, the certificate.
Lordship
under
kindly
section
say so.
56, when an endorsement is issued and that amounts to the refusing to grant the fitness certificate, petitioner's remedy is under section 56. If there is any order of this court, the same can be brought to the notice of the appellate authority. And when there is an effective alternative remedy in each and every case, the court cannot exercise the jurisdiction under Article 226 of the Constitution of India. And this court is not inclined to pass any order. And accordingly, this court is passed the following order. The writ petition is disposed of, directing the respondents to avail the remedy under section 57 of the Act within a period of 1 week from the date of receipt of the copy of the order, and the appellate authority shall consider the same in accordance with law.
Within-
And in the next matter,
Within some limit, time limit.
1 week is it?
No, to dispose it of the appellate, please.
That in 32 also, there is a endorsement date is what? Your case.
Also same thing.
Endorsement date 2/6/26.
It's only fitness.
Only date.
2/6/26, my lord.
In the other case, it is 2/6. Otherwise, everything is same.
And section 57, my lord, appealable order.
Appealable under section
56.
Then look at, yes.
Number 2. Hearing on written application, sale number 1.
Please, one, my lord, there is a passed over matter. May I request your lordships or tomorrow, my lord, or in the afternoon? My lord? There's one matter, item 22 was passed over
I'll take it up if time permits in the afternoon.
afternoon.
If time permits, or else I'll take it up tomorrow or whenever it's convenient.
Lord, there's some urgency, that's why I'll take a chance at 2:30, my lord. Please.
Yes.
Cell number 2.
What about 1?
1.
1.
It is not mentioned. He is referring to passed over matter, Anita.
So
Yes, call 1.
I think cell number 1. Number 2, cell number 1. Ajay Rao.
What is this IA 1024 for dismissal of writ petition? Oh, this is a
This is
matter.
the. My lord, your lordship said
Yes,
yesterday.
yes,
because
yes.
so direct.
Yes.
Lords, I'm submitting the translated copy of the commissioner's report. That's where I had stopped yesterday, my lord.
Yes. Yes.
Lords, can I just also request, my lords, your lordships may have the writ petition papers, the last 2-3 pages, because that's where the sketches, the commissioner report has to be seen along with that sketch. This is what.
At page 124.
There's 2 vehicles.
Yes, 124.
Your lordship will see page number in this report, my lords, page number 3.
No, it's just the sketch.
The sketch
Is it
is
at
what I
120?
am requesting your lordships to hold it along with this report.
No, is it at 124? Page number 124?
Yes, my lords.
Oh,
Page
yes.
1, yes, that's the sketch.
Yes. Yes.
Is that the sketch? But 124 is something else.
To continue. 124.
Lords, page number 5, notes of this translated copy. Lords, I will not trouble your lordships from serial number 1 to 5.
Yes.
The questions are there. I will not trouble your lordships from serial number 1 to 5. Then serial number 6. Ascertain and report to the honorable court if item number 3 is irregular key shaped, and also report on which the depth ratio of item number 3. Item number 3 is a palm shaped and the width and depth is marked in the sketch. Notice it's palm shaped in the sense that in the front towards the road, it is larger. As we go down, it narrows down. The property narrows down.
This one, page 7.
Yes.
Now next, by applying BDA rules and the regulations inform the Honorable Court as regards what is the permissible FAR achievable for the whole of item number 3 property. But I'll just read it from the previous page. As per chapter 4.5 of the rules, zonal rules excerpt is contained in annexure. If the width of the existing road connection to the land in question is more than 30 meters, the maximum coverage that can be approved is 50% and the maximum floor area ratio is 3.25. Accordingly, the width of the existing National Highway 44 road adjacent to the west of the land in question is about 60 meter wide. The questioned item number 3 of 2 acres 28 kuntas as approved by RNP so also is facing mutation corridor zone. If the item number 3 property is divided equally in 3 parts as per the zoning regulations, because I just pause here before that I just wanted to point out, if this property were to be used or utilized together, then the entire extent of 2 acres 28 kuntas will be given an FAR of 3.25. That means the whole of the property will get 3.25 because it's a property meant for development. So 3.25 FAR is what this property can achieve with the existing road. Now he gives options. Option number 1. In the light of plaintiff stroke defendant as the sketch number 1, a maximum FAR of 3.25 will be available for block number 2 area. Rest block 3 and block 4 areas shall have a maximum coverage of 55% and a maximum FAR of 2.75% as per block 1 with minimum 12 meter approach road to be reserved from National Highway 44. Let's now kindly see that first sketch. Block 2 is the front, block 3 and block 4. This is how it has been given. Block 1 is the road.
So how do you, what is this block?
I'll
Sketch
just
at
point out.
124.
Block, the Roman 2 minutes is block 2, Roman 3 is block 3, Roman 4 is block 4. On the top of it, that's on the northern side of it, your lordships will find that there is Roman 1 mark. Block 1 is supposed to be the road for 12 meters approach from block 12, block 2, block 3 and block 4, which runs continuously from the road till the end of the property. Lordship gets it, not the first sketch.
No, I can find item that Sankhya 4.
Yes.
And 3 I can find. Where are 2 and 1?
No, Malad, if on that sketch, if the Malad looks at the first figure.
Not here.
What?
This is block 2, this is block 3.
No, I think what I am looking at is not what, we are not on the same page.
Just check. What is that page number? No, it's page 124, that's the correct sketch.
No, that's the next page.
124 is this.
There's one more before that.
I don't need it. Here's the wrong one. My lord, may I have this.
Take that.
A little bigger sketches there, if I can assist your answers with that sketch. After going through this, I demonstrated as to how this valuation gets hampered and pampered in favor of the.
It is 1, 2, 3 and
yes,
4.
2, 3 and 4. 1 is the road. So this is option number 1. Next, option 2. Block 1, block 2, block 3 in the claim of the plaintiff defendant as per sketch number 2. Direct road connectivity from the existing National Highway 44 road on the western side is suggested for all 3 areas, thereby providing a maximum FAR of 3.25. But the road frontage of 3 parts is approximate and the land width is very less. Therefore, for building construction, the height of the proposed building zonal regulations table number so it is not possible to carry out any construction of a suitable building if the spaces are reserved as per the rules. This is strips. That's sketch number 2. 1, 2, 3, 4 are there. Notice they wanted to divide it like this. It is not possible to put up any construction by anybody. Then block number 3. That is option number 3.
Yes.
In the right of the plaintiff's defendant as the sketch number 1, a maximum of 3.25 FAR will be available for block number 2 area. Rest block 3 and block 4 shall have a maximum coverage of 55% and a maximum FAR of 2.75 as per block 1 with minimum 12-meter approach road to be reserved from the existing National Highway 44. That is again, you know, if your lordships were to see, they have just shifted the road from north to south. That's essentially what they have done. The difference between sketch 1 and sketch 3 is, sketch 1 there is a road on the northern side, the sketch 3 minutes they have shifted the road to the southern side, nothing great about it. It again runs from eastern end to the western end of the entire property. It is a long property. Then sketch number 4, option 4. The right of the plaintiff, defendant as the sketch number 1, a maximum of 3.25 FAR will be available for block 2 area. Rest block 3 and block 4 areas shall have maximum coverage of 55% and maximum FAR of 2.75 as per block 1, with minimum of 12% approach road to be reserved from the existing National Highway 44. Now this is what is accepted.
No, for all except for option 2.
Yes.
For option 1, 3 and 4, they said
Yes.
it's FAR of 2.75.
So the FARs to the hind portion of the property gets diminished to 2.75, and the front portion of the property, it will be more. But now the question is, you are calculating on the basis of how much FAR a property is likely to get. The property which is adjacent to the main road costs almost 1.8 times the property which is on the hind side, because of the property being adjacent to this main road. The minimum which is required in any commissioner's report is to come to the approximate valuation of the property as to how this equitable distribution is made, not on the basis of the utility of the property. Valuation should be made. But now, if your lordships were to see clause 8.
Clause 8.
Yes, in the same report. By applying BDA rules and regulations, inform the Honorable Court as regards what is the permissible FAR if item number 3 were to be bifurcated, and if it is possible for all 3 bifurcated properties to achieve the same FAR. The answer is item number 3 property as described in the preceding question paragraph to the plaintiff given in 3 parts. An option has been given if the properties are made equal divided according to the rules and the building map is to be approved by the local authority and achieve uniform FAR and ratio. It will be difficult to carry out the construction of suitable buildings after reserving the spaces in the properties which are divided into 3 separately according to the height of the building as per the rules. Now what happens? You are squeezing an extent of about 2 acres and 20 guntas. You exclude the road portion, then cut it into 21 guntas, 28 guntas, 28 guntas. Now if I have to achieve this FAR, it's a question of how much height I have to go. Now, if these height regulations are to be implied with, in respect of the kind of division which they are making, he says that it is not permissible to put up or achieve this FAR at all. We can't put up the construction, because between every building I'll have to leave this space. Now, this is what the commissioner himself said, that it is not possible. This it's not a question of the mechanical way in which the trial court does this exercise. That's the reason why I said I'm really startled. Because these are some minimum things which is to be understood by the trial court when they are causing the partition.
No, please come back to the order.
Now I just indicate, what is the financial loss which will be caused. I just pass on this calculation which we have made. It's only as per the reports of the commissioner. This was produced before the trial court. I can, we have produced this along with the memo before the trial court. You are doing injustice, please don't do it.
Yes.
I will straight away go to option number 4, because option number 1, 2, 3 is not accepted. I will not trouble. This had to be produced before the trial court only because of the fact that there were 4 options. Now only one option is before your lordships. Kindly have a look at the last column. Your lordships will find, on the first column on the left hand side, we have given what is to be looked into in the last column. I am referring to Commissioner report option number 4.
Yes.
Then I will come to the row 1, 2, 3, 4, 5, 5th row, available area for each of the parties. After that blue portion, then your lordships will get
available area.
Yes. Before that, if your lordships were to see that blue area, if at all this property is developed together with all the 3 persons together, we give it to any joint development. Because this ire which I find, my lords, in the eyes of the sister is what is actually destroying the family. She may have some personal grievances about the way she has been treated, etc., etc. That appears to be the bone of contention. She wants to destroy, doesn't matter. But if your lords were to see that blue portion, 3,82,239 square feet divided equally amongst three parties will be 1,27,403 square feet of built-up area would be achieved for each of the parties. This is actually what could be achieved in case if it is to be developed jointly. Now next, let's make a see available area for each of the parties.
Each one will get 1,27,413 square feet.
Yes, constructed area. By achieving 3.25 FAR because it's adjacent to the main road for the entire building, this is what could be achieved for all the three parties if there were to be a joint development by all the three parties.
Yes.
Now, available area for each of the parties, last column, if your lots were to see 29 guntas, which is equivalent to 31,581 square feet of land. Then, area lost due to access due to the road is 21 guntas, which is equivalent to 22,870 square feet. Next, available FAR for each of the portions as per the report. Now, let's kindly see portion number 2, 3.25, they can develop. Portion 3, portion 4, we can't develop. That is what I read from the report, serial number 8. We can't develop this individually. Now, next, achievable built-up area for each of the portions as per the report. Last column, portion 2 is 31 into so and so, that is 1,02,638 square feet. Portion 3 and portion 4, we will not get the plan approval. No, that is what the commissioner includes because an official of the BDA. Next, your lordships may kindly see. Considering the table 8 and 9 of the BDA bylaws for setback achievable built-up area for each portion, then portion 2, 70,000 square feet of built-up area, portion 2, portion 3, no construction can be put up. Then your lots may come to the next page. Lord, this is a converted property which comes under the BDA. Now your lordships may kindly see what is that we are going to lose. I will not trouble your lordships over that because these are the things which is to be considered. This is there is something called as common commercial sense. Whenever such things are being worked out, it should be borne in mind that there is something called as common commercial sense with which this is to be done because what is required to be caused is an equitable distribution of the properties. Last column, lords, revenue loss to the party due to the reduced construction area post division assuming 42% owner share of 6,000 square feet, overall loss to both developer and party. Last column, lords.
Yes.
Portion 2, 12.2 crores, they will lose, overall loss will be 29 crores. Portion 3, they will lose 33 crores, overall loss will be 78 crores, and portion 4 will be 33 crores, will be the land area, overall loss will be 78.5 crores. Lords, I just wanted to say this, lords, that this is a comparison with what would happen to this property in the nature of the division of the land. That is what is in the first column, portion 3, 33 crores.
Yes, I understand. Yes.
But now, if this is the manner in which I am faced with this, and now your lordships will see one thing which is very, very interesting, lords. Lordships may kindly have a look at the sketch. Because
yes.
Lords, in this what your lordships will find, this is the sketch which is accepted because only to show that there is so much of laxity of application of mind. If your lordships were to see that road, that is block number 1, yes. He says 9 meters. But block number, option number 4, he says, you cannot do anything without there being an excess for 12 meters.
No, I understood that. What is your bone of contention? Let's go to the order now.
Now your lordships may kindly see the order. It's an ipsit dixit order. Means absolutely nothing in the order in the manner in which we presented the matter either before the trial court or before lordships. But para 15 and onwards, my lords.
Page number?
Lords, page number 27. I can even skip at para 15 and para 16, my lords. But anyway, I will read because it will have the continuity of how the trial court probably has applied its mind. Para 14 is where the court says I have considered the sub-contentions. At the outset, it is necessary to note that the commissioners were appointed to give a report if it is not feasible for partition. And if they are of the opinion that the division can be done, then they should divide item number 3 by meets and bounds. In this regard, it is observed by the commissioners' report. The commissioners, they nowhere stated that the partition is not feasible. In fact, commissioners have partitioned the property into 4 parts, including the access roads. So kindly permit me to pass here. Commissioner never said that property is capable of being partitioned. Commissioner gave the options by saying that in the event the property is partitioned in option 1, 2, 3, 4, property can never be partitioned for the purposes of its utilization.
Yes.
So essentially the commissioner gave a report saying that it is not paritable.
Yes.
Next. At first, it is necessary to note that the sale as envisaged in the Partition Act comes into play when the property is too small to divide or when there are more sharers and partition of the land is possible as per the expert opinion of the commissioner. But in the present case, as discussed, Supra, the commissioners have not opined the partition is not feasible. On the other hand, they have divided item number 3 equally with an access road. Even as per the submission of different numbers 1 and 2, if the court has to proceed on the same item number 3, the same cannot be done without the consent of all parties. In this case, plaintiff is not ready for selling her share or auction of item number 3. It is also pertinent to note that as per the submission of the advocate for defendants, measurements in the sketch furnished along with the commissioner's report as per Anekal master plan rules. As such, it can safely be said that commissioners have divided the item number 3 into 3 portions with an access road as per the rules and regulations. View of the discussions made supra, sketch 4 proposed in the commissioner's report is accepted.
The last. On the merits of the matter, you have argued on the maintainability.
My
Now
lord.
on the merits.
My lord, at the outset, my lord, all the arguments that my lord has heard,
I have to make a mention
Yes.
of 130.
Yes, yes.
all the arguments that my lord has heard thus far, my lord, on the merits of an order that is passed by the court below, a final decree that has been passed to be heard in an appeal. My lord, a list is given out like this, not contained in the writ petition, but stating certain facts here. Where has this to be adjudicated and where is this to be? No, definitely, I mean, they may have a grievance with what has been done, but the forum for it is an appeal. Now, my lord, kindly see, this is a case in which a writ petition is filed. Now, my lord, what my learned friend did not show it on the merits of the case is, if my lord goes back to that sketch, if my lord looks at the sketch, the property that is on the right side, they claim that is their self-acquired property, and that is the property that is being developed. At the outset, my lord, in the case of determination in respect to the property, it is to be taken with respect to the value of the property per se, not on the basis of whether I will build Taj Mahal on it or whether I'll build something else on it. The question is not about what is the nature of construction I'm going to put up on that property.
Before going into that, the court records a finding at paragraph number 17. And whether the commissioner report was considered by the court. No, one issue is that I'll consider whether a petition is maintainable or he has to go in appeal.
Yes.
Provided if the court considers that we have to go, the court, this court can consider that this is not a decree.
No, my lord. The court has considered the commissioner's appeal. We have seen that, we have read the order. Court is considering it. My lord, court may have wrongly considered it. If the court has wrongly considered it, it's not an error of jurisdiction at all.
If it is not a decree,
yes,
then it is not appealable. And if they have the right to come before the
court. My lord friend himself conceded that I am not saying it is not a decree. My lord, once it is said that it is in the nature of a determination finally in a partition suit, the court has said draw up a final decree.
I heard both of you and I'll pass orders on that. So let's not go back to that.
Yes.
I'm saying if it is not a decree, so if the court can consider this repetition,
yes,
in that case, this observations of the court,
yes,
can't be sustained. No application of mind on the commissioner's report is what appears.
No, my lord. What is not furnished before my lords is the written arguments filed. Let me just complete. My lord, their stand that no, you allocate any portion to them. I am okay with you allocating any portion to them. their contention was, no, you can't make this division. Now kindly look at the writ petition. The writ petition is not saying that this allocation, I should have got this portion or some other portion. Not maybe if they're saying some other portion, I may even concede. I may even say, okay, take that portion. That's not what they want. They want to develop all of it together. They want me to join them in the development, which they can't compel. They can't compel me to join them in the development. And not kindly see in all this, what is now completely missing is they pointed out a road on the left side and said, oh no, please see the FAR here. But what is in development actually is what is on the right side, because on the right side is the rest of the property, where they are putting up a construction. They want this to be a part of that. Now, my lord, irrespective of where I am allocated in these sketches, they will have the same issue because the development that they are contemplating is part of that developments on the neighboring properties. Now, may I request now to kindly look at one order before this honorable court. Kindly go to.
That is Justice Shyam Prasad's.
No, my lord. Before that, there is one more order. Kindly go to my objection statement. My lord, when interim orders, when the suit for partition was filed, there was an interim order that was passed. Then, my lord, that interim order came to be modified by this honorable court. If my lord looks at my objection statement, kindly go to page 40. All this argument about FAR, what will be the effect of FAR, etc., in respect of a property?
Are you referring to this memo for production of documents?
No, my lord, I'm referring to my objection statement dated 13/8/24. Yes. I'm referring to page 40 of that objection statement.
Page 40.
Yes.
Yes.
My lord, this is a judgment of this honorable court. This, my lord, is an MFA in respect of the injunction that was granted saying, please don't alienate any of these properties if the partition suit is disposed of. Now, my lord, that interim order came to be modified by this honorable court. Can I request now to kindly go to page number 62 at paragraph 19?
Yes. Yes.
I'm reading para 19. Defendants 1 and 2 claim that they want to develop the property and therefore the plaintiff can take 1/3 in any part of the said property so that they can develop the property of their share. They wanted their shares to be contiguous. They wanted their share to be contiguous with the portion at the back. And today, my lord, all this to contend something else. And my lord, kindly see, my respectful submission is.
What is this?
No, my lord, this was as against an order on.
Whatever it is, your submission.
Yes. Here, what had your lordship should read the entire paragraph. My lord, what had contended was that I want to develop the entire property. I'll earmark 1/3 share in the developed portion to the plaintiff so that development doesn't stop. My lord, what learned senior counsel has not pointed out. Item number 4.
Defendants 1 and 2 claim that they
Yes.
want to develop the said property. Therefore,
Yes.
the plaintiff can take 1/3 share in any part of the said.
Part of the development, my lord. What? That's the reason why the honorable court permitted us to file an application under section 52 so that we could seek for development of the property. Since we had
What
yes.
is put forth before this court is
Yes.
that is not a equitable partition. If this part is given to one,
Not
then
ultimately.
what would be the loss and all?
Not-
No, when it is, you say that any part it is fine with you.
any part of the developed property, my lord, because what we wanted to achieve there was development of item number 3 and 4, my lord. Item number 4 is at the hindsight of item number 3. That is belonging to the petitioner herein, my lord, because item number 3 is not getting developed. Item number 4 is also, my lord, today, as of today, a vacant land. My lord. It is not as though it is developed as what learned senior counsel said. So what we had said here was that permit me to develop so that I can give her 1/3 share. Today, it should not be in a stalemate is what my submission was.
Yes.
No, it's incorrect. Can you see? It doesn't say 1/3 in the development. It says you can take, therefore the plaintiff can take 1/3 in any part of the said property so that they can develop the property of their share.
Later on,
this is the submission that is made. And this is the argument that is advanced before the court below also. And now, my lord, to contend something else. And, my lord, all these are contentions on facts, on what is valuation, whether this should be correct, not correct, how it should be done. All of these matters in appeal at best. And there is no hurry in any of these things. This has to be decided in appeal. And in appeal, all this will definitely be considered.
Not in the same paragraph, my lord, we say that if the honorable court says, on that count, the injunction order cannot be vacated, nor can defendants number 1 and 2 be permitted to alienate the said property. If at all the defendants number 1 and 2 intend to alienate or develop the said property for their benefit, in view of section 2 of the Transfer Property Act, it is always open for them to seek leave of the court to develop the property. And that's what happened, my lord. We did not want it to be a situation where the maximum FAR could not be achieved, because any bifurcation would deteriorate the property was our submission, and it has been our constant submission before the honorable trial court.
My lord, IFF.
Can I just pass on a few judgments, my lord, which I did not do yesterday?
Take that.
My lord,
I'll consider those judgments, any relevant.
can I just can I just mention if my lord looks at the questions, my lord, in the judgment of Ramat Pathak, my lord, division bench judgment of the Patna High Court, my lord, may kindly look at paragraph 4.
Yes.
The solitary question that emerges in this case is whether a person aggrieved by an order confirming commissioner's report under order 16 or 26 rule 14(3) of the code can prefer a revision under section 115 so and so, because admittedly under order 23 rule 1 does not prescribe an appeal against such order. Then my lord may kindly look at paragraph 9. According to the opposite party, the moment a report of a pleader is confirmed under rule 14 sub rule 3, aggrieved party can at best lay an appeal against such order under section 96, but not a revision under 115, because such order has to form a part of the decree, whereas the counts were so and so. And then my lord kindly see in paragraph 11 and on the next page.
Yes.
In my view, a bare reference to the explanation attached to subsection 2 of section 2, read with the stipulation under rule 14(3) of order 26, it would reveal that no revision can be maintainable against an order confirming the commissioner's report. We have already indicated that as per the explanation attached to subsection 2 of section 2, a decree is preliminary when a proceeding is required to be taken before the suit can be finally disposed of, but it is final when such adjudication completely disposes of the suit. Thus, if a court confirms or varies the report of a pleader commissioner after adjudication, such a report shall form part of the decree. The aggrieved person against such confirmation can only prefer an appeal after the decree, but no revision would be maintainable. Now, my lord, this is not a revision, but a writ petition. Now, my lord, may kindly then look at Amiya Bhushan's case. In that, my lord, in paragraph 4, they refer to section 2, the definition of decree in section 2, subclause 2.
Yes.
Then in paragraph 5, my lord, they refer to section 97. And in paragraph 6, from a bare reading of these provisions, manifestly clear that appeals lay both against the preliminary decree and also against the final decree. But the scope of these two appeals are limited. In an appeal against a preliminary decree, one can challenge the legality and entitlement of the share adjudicated by the court in the preliminary decree, whereas in an appeal against a final decree, one can challenge the allotment of the property and so and so, again given by the court commissioner, etc. Then, my lord, this honorable court's judgment in Iramma's case, my lord, paragraph 2, there, my lord, it was a writ petition, and the court said so. Then, my lord, I would like to just refer to one other judgment. So kindly then also look at the judgment of the Honorable Supreme Court in 2022.
16 SCC.
My lord.
This is the one.
My lord's got that answer. Yes. Yes, my lord. Kindly just look at paragraph 35 at the end. My lord. The court then, my lord, court says this whole concept of making a preliminary decree and then final decree, etc. It said all this is resulting in enormous wastage of time. So the court is now duty bound. And in fact, there's a circular that's passed by this honorable court to say, as soon as you pass a preliminary decree, now the court should proceed to the final decree without having to wait for somebody to file a FDP petition. And that the court should go ahead. And that this process is seamless and continuous. So this is what has been done in this case.
I also rely on some judgment, but I already extracted the relevant paragraphs.
Yes. Para numbers are mentioned.
Yes, my lord, we've extracted the relevant paragraphs.
Yes.
My lord, IFF for R2. Just one point. While I adopt everything the learned senior for the petitioner said, the only one point is, my learned senior here said that it is jointly being developed. Item number 4. Item number 4 is the petitioner's cell phone property. We as respondent to join to this because the intrinsic value of the property gets lost if we don't get the maximum FAR. As my learned senior said, it has to be equitable partition. End of it all, we lose because this is the only property that we have. If we are made to then lose about 0.75 FAR, the value of it goes completely, which is not an equitable partition. That's all I'll say.
Dissolve.
Great.
Obliged.
Signature. No, 4 o'clock and this. I'm not supposed.
With kind permission, that firstly serial number 25. I was not there when the case was called. My absence is noted, blood my kind. Serial number 25.
Tuesday in the motion, in the first list.
Serial number 25. Much.
ಯಾವ್ದು?
First list.
Serial number?
25.
25. 25 no representation ಅಂತ.
ಅದಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಆಯ್ತು. ಫಸ್ಟ್ ಲಿಸ್ಟ್ Tuesday. ಅದು ಲಿಸ್ಟ್ ನಂಬರ್ 59.
The list to see number 5 stay extend ಆಗಬೇಕು.
ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಅದು ಮುಗಿತಾ ರಿಸರ್ವ್. ಸರ್ ಎಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಎಲ್ಲ ಲಿಸ್ಟ್ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ.
List to see number 5 stay out extend ಆಗಬೇಕು.
ಎಲ್ಲ ಆಗುತ್ತೆ.
List to see number 5.
ಲಿಸ್ಟ್ ಕರೀತಾರೆ ಸರ್, ಈಗ ಬರೀತಾರೆ.
ಸರ್ ಯಾವಾಗ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ, ರೀಚ್ ಆಗಿದೆ ಎಲ್ಲ ಯಾವತ್ತು ಥರ್ಡ್ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಆ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಲಿಸ್ಟ್ ಬರುತ್ತೆ. ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ ಇರುತ್ತೆ, ರೀಚ್ ಆದಾಗ ನೋಡ್ಕೋಬೇಕು ನೀವು. ಬಂದಿದ್ಯಾ? ಹಾ 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 ಹಾ
You dispose.
ಅವತ್ತವತ್ತೇ ಅಪ್ಡೇಟ್ ಆಗ್ಬೇಕು. ಗೊತ್ತಾಯ್ತಾ? ಯಾರು? ಆಯ್ತು, ಮೇಘ ತಗೋತಾರೆ ಬಿಡಿ, ಮೇಘಾಗೆ ಹೇಳಿದ್ರಾಯ್ತು. ಮೇಘಾಗೆ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ಹಾ. ನನ್ಗೆ ಒಂದ್ ವಾರದಿಂದ ಹೇಳಿ ಸಾಕಾಗಿದೆ. ಏನೋ ಒಂದ್ ಮಾಡುತ್ತೆ. ಅವ್ರು ಇವ್ರು ಜೈದೇವ್ ಈ ಬಾ
on the list. Yes.
Continuation of list number 2, serial number 2, serial number 2, VD Raviraj.
Yes.
For the petitioner in this matter.
Yes.
The respondent 1 to 7.
What is the suit for?
A suit for partition, my lord.
Which year is the suit?
Suit is for 2006 it was filed, my lord. Filed by the respondent 1 to
Yes.
7.
Yes.
Claiming that the suit scheduled properties are the ancestral properties against the petitioner and respondent number 8 to 10, my lord.
Yes.
The petitioner is the third defendant. Third defendant, his son, her son. Now he is no more. She is the LR of the third defendant before the trial court. During the pendency, there is a compromise was entered into between the parties. Compromise petition is at page number annexure, page number 37, document number 4, my lord. As per the compromise, my lord, the parties have the petitioner and other respondents 8 to 10. They agreed to pay a sum of rupees 15 lakhs to the plaintiffs towards the full and final settlement of the properties. And other terms and conditions they have clearly mentioned therein, my lord. Insofar as the out of the 15 lakhs, my lord, 1,75,000 is paid before the court by cash, my lord. The remaining amount is issued by check, my lord. All the 3 defendants have issued two checks in favor of the plaintiffs. During that, in the meanwhile, my lord, one of the defendant, he has disputed the compromise and filed a miscellaneous petition before the trial court. The said petition was notice was the order for that, and then plaintiff has come up with in the said petition, and he said that he has no objection to allow the petition. But trial court dismissed the miscellaneous petition filed by the one of the defendant. And in the meanwhile, ma'am, the checks issued by
What was that miscellaneous petition?
miscellaneous petition for restoration of the original suit, setting aside the
Set aside the compromise decree.
compromise petition. That was dismissed. Later, he filed a writ petition before this honorable court. That has also been dismissed subsequently. It is withdrawn as dismissed as withdrawn. And in the meanwhile, my lord, the checks issued by the parties got dishonored. And thereafter, my lord, thereafter, the second, the first respondent, who was the plaintiff before the court, the plaintiff, all the plaintiffs, they filed an application before the very same court which passed the decree, compromise decree, for restoration of the suit, because condition of the suit has the defendant have not complied the provision.
The compromise decree cannot be executed.
Compromise decree can be executed.
Because if there is non-compliance of the decree, they should be set aside.
But for that reason, my lord, it was been set aside. That reason it has been set aside. Though it is the decree is a money decree and the suit schedule properties are still available. Then they could have filed instead of allowing the application for instead of restoring the suit, my lord, they could have executed the decree and the recovery of the money or
come to the impugned order.
Impugned order, my lord. Impugned order at annexure, in page number, my lord, the 78, my lord.
Yes.
78. Relevant portion is, my lord, para number 16, my lord, 86 is it. In page number 86, para number 16.
Page number?
86, my lord. 86.
86 says objections of the defendant. This is CRP 117?
Yes, 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 ma'am. The document number 10, my lord, order sheet, it starts with order sheet.
Yes, it is at page 89, 12 and 2026 order. Yes.
It is
where is the relevant?
Para number 16.
Yes.
A perusal of the compromise petition shows that the plaintiff agreed to receive money compensation in lieu of their share in suit item number 4 to 6. The defendant jointly agreed to pay 15 lakhs, out of which only rupees 1,75,000 was paid in cash, and the remaining amount was paid through 6 checks. Order 23 Rule 3 of the Code of Civil Procedure mandates that the compromise must be lawful and voluntary and not opposed to the public policy. The underlying object of the provision of the to bring the coitus of litigation and prevent further dispute.
Para number 18.
18.
Checks were issued under the compromise. 4 checks were issued in the name of persons who were not parties to the suit.
That first defendant, my lord, first defendant issued the check of his daughter. Second defendant issued his proprietary concern check has been issued, my lord. The third defendant has issued his checks only. The assuming for a moment, court is under the impression that the 138 proceedings is only the remedy. That is not correct. Even civil remedy is available, though it is the check belonging to his daughter. The father liability, the defendant's liability is always there, my lord. In the present case, the material on record clearly established that out of the 6 checks issued under the compromise, 4 checks were issued in the names of persons who were not parties to the suit or the compromise proceedings. 2 checks were issued in the name of Kamala, the daughter of the defendant number 1, and 2 checks were issued in the name of Rameshri Enterprises. There is no explanation in the compromise petition.
Yes.
did the compromise happen? And subsequently, the law should say whether it is clearly mentioned that the checks are listed, that the checks are the different persons, not concerned to the parties that are issued.
That is with regard to if it has to go for 138 and all. The checks were issued by persons who are not parties to the suit,
Yes.
and they cannot take action. That is what is the order of the court. Observation.
Then, the earlier petition what my learned friend submitted, that the one of the defendants, the first defendant fails issued the check, he himself has filed a misleading under the wrong provision. Because of that reason, that petition came to be dismissed. Then subsequently, my lord, the liberty was given to him to file an appropriate application before the same court because of the recalling the order passed under the 23. Because of the he filed an application that was allowed. Even your lordship can see how they are cheated. They are all brothers and sisters. Your lordship can see checks were issued and property was taken by them. When the checks were dishonored, it is the at least no courtesy to say that they will pay the amount immediately.
That shows the conduct of the parties. But is it a ground to set aside the compromise decree? If the compromise decree is not honored, only available.
Decree only on the ground that they have issued the checks for that reason only that was decreed.
No, there is no other way to execute the decree.
There is other way, because your lordship can see, then if I find a suit, these are either under the 138 proceedings or the some other procedure. Then how long I have to wait for the recovery of that amount? Here your lordship can see how whether they have to at least obey these documents petition as per the conditions imposed on that, they have to pay the.
Yes.
Even at your lordship, if this compromise is recalled, what will happen? No, in the minutes of the case, they will get their share.
That is what will happen is what will happen. But what is available to the court, whether the court was right in doing this or not, is a question. Whether the court can set aside a compromise decree because it is the terms of the decree are not honored. So every decree, wherever a compromise decree is not honored, the remedy is to set aside it.
Only the criminal decree was passed, the final decree was not passed. That is still pending. Because of that reason, they have recalled the order.
Yes, heard reserved. Next.
Then number 3.
Honorable, this division bench of this court were not. It is reported in 2015, 4024. When they are not in the center. That was 17 of the judgment, my lord. That was 16 and 17. Para 16. The validity of a consent decree depends wholly on the validity of the agreement or compromise on which it is made. It is open to the parties to be compromised to show that the agreement is not lawfully and misrepresentation, fraud or mistake. They were made to agree such compromise. A consent decree operates as an estoppel and is valid and binding unless it is censored by the court which passed the consent decree. The explanation to the proviso says that an agreement or compromise is void or voidable under the Indian Contract Act and shall not be deemed to be lawful within the meaning of this clause. And the next paragraph 17. In the instant game, the suit is filed by the plaintiff for setting a compromise and consequent decree passed in so. The Honorable District was challenged on the ground that it is initiated on the ground fraud and misrepresentation such a suit was not maintainable. Therefore, the trial court was justified in invoking order. Here also your lordship comes to.
No, like how this judgment is helpful to the petitioner, I didn't understand. What is the ratio in this and how is it applicable to the facts of the case? No, where is the, no, this is with regard to an order 7 rule 11 application.
That is 17, 16, and the compromise settlement was made and subsequent to made the complaint and discharge. Then it is limited.
I'll consider. Yes. Any other judgment?
No, even subject to this degree, one more compromise petition by this the family partition should strike. That is still pending.
Yes, call the next matter.
Cell number 3, hearing on interlocutor application. Sohas G.
Yes.
Not appear for the case.
Where is the affidavit?
Madam, please.
Take that.
Yesterday, Apex Court has cancelled the sale which was took place 16 years ago. Only thing is that 5 days delay in payment of the balance of the.
So many things happen.
It differs from case to case, my lord. The peculiar
Yesterday there
circumstances
must
of
be a
that case.
judgment of the Supreme Court in the facts and circumstances otherwise.
Even this.
Anyhow, don't, unless ultimately you want your money.
No, what I'm telling you.
So let's not waste time on this. This court has disposed of the writ petition on 30th April 2026, whereby the impugned communication dated 12/3/2026 passed with the bank is set aside and directed the petitioner to pay the remaining amount by 30/5/2026, or else the respondent bank is at liberty to forfeit the amount that is paid with the petitioner. Now, the petitioner has come up with an affidavit before this court, filed an IA seeking modification of the order and also seeking extension of time. It is submitted that the petitioner is suffering with dengue fever, and even till today is hospitalized. As such, where is that?
Lord, the blood report.
Where did you say the time?
In affidavit, page number, para number 4, my lord. 4. Para number 4.
Para number?
4.
Where did you say about the time?
Yeah.
Time. I said 15 days and you should file an affidavit.
My lord, 15 days, my lord. Because these are still undergoing treatment, we are not sure that he'll be undergoing.
I'm also not sure to pass this order.
My lord.
That's what I made it very clear yesterday. I'll be granting time to you. I'll allow this IA, provided you file an affidavit that you'll pay the money within 15 days. Just like that, filing an affidavit will not serve the purpose. And I'll not consider it.
My lord, the kindly order be passed, my lord. I'll deposit within 15 days.
No. Why should
Within 30
there
days.
should be an affidavit on record. You file an affidavit tomorrow. With 15 days, I'll pass tomorrow.
Please.
And tomorrow, if the same thing continues, I'll dismiss it.
No,
I'll not give any further time. At the request of the learned counsel, this court has specifically directed the petitioner that he shall come up with an affidavit that he is ready to pay within 15 days, or else the time will not be extended. Today, an affidavit is filed, but there is no mention about the time. Finally, let's this matter tomorrow. By the time that the affidavit is filed, mentioning the time of 15 days from whatever the date they have, then otherwise the IA that is filed seeking extension of time will be dismissed. Yes. Yeah, this matter tomorrow in the first list.
Notice
Notice is not ordered, other than we take accept the notice for 1 to 7.
Yes, next.
Cell number 4.
For the petitioner, my lord, on this case, we would
Yes,
like to
yes.
file a rejoinder to that, whatever the application filed for them to vacate interim stay, my lord.
Petition which they filed, they are the plaintiffs, my lord, and defendant. They were not granted an ad interim injunction, as against which they have filed.
No, in a writ petition, what is the rejoinder?
My lord, they have,
objections?
my lord, that is the case, I'll argue the matter, my lord. I'll
We
draw
can
your
only-
lordship
we can
attention at
only
page number
consider-
29, my lord.
We can only consider what is the order of the
Yes,
court
my
and
lord.
what is the material that is placed.
My lord,
Not all these.
Interim order was not granted, I had filed a writ petition to this honorable court. This honorable court has granted me the status quo order, my lord.
No. What is the suit for?
Suit for injection, my lord.
In that you have filed an IA and IA was dismissed.
Yes, my lord.
Against it, you have come to this
Yes,
court
yes,
and
my
this
lord.
court has granted.
It granted me to maintain status quo. So both the parties are
Where is that
directed me.
order? When was this order passed?
During the vacation.
Not vacation, no, before the vacation.
Yes.
Prior to the
No, please argue.
My lord, I just draw your lordship attention at page number 29 in my petition, my lord.
20.
29, the type copy of the RTCs, my lord.
Oh, before that, we have to see the order. What is the order? Why the court has not granted injunction?
Trial court has
Issued summons.
only issue notice, my lord, that's all. Summons.
No,
Thing
let the trial court decide this.
No, it's today. We have filed our objections also in the trial.
Lord, it has to be, all that has to be considered by the trial court. Many documents are there to be, my humble submission before Lordship is, they have furnished the revenue records not pertaining to the village which they are contesting. That is the villages.
No, I'm not on the merits of the matter.
Yes, my lord, please.
Matter is coming up before the court. Court
Yes.
has to hear it.
Yes, my lord.
Go before the court. Let the court decide it.
Yes, my lord.
Till what you do is, I'll ask the court to decide this application.
Yes, my lord. The direction it may be disposed of. Please, my lord.
Within 10 days, till such time, this or whatever the order he is enjoying from April, let it continue for this 10 days.
Can I just make this submission? My lord, I have a land which is around little more than 5 acres. Suit scheduled property, he claims to be 6 guntas. In the suit, he claims the land is vacant land. In my statement of objections, I have shown that there is a building of over 20 floors put up. Construction is
According to him, it is a
vacant land.
According to me, it's vacant land, my lord. They
According
have,
to him, it is vacant land.
my lord,
Now, what he
that,
has done, my lord, after being granted the status quo order, I produce along with my statement of objection. He has been defacing the entire property by bringing people and putting signages, including photographs of Dr. Ambedkar on the property. And I can show you the photographs. These are the kind of photographs.
What is that photograph?
Yes.
This order of status quo is very dangerous.
Yes, my lord. Because it doesn't exist.
Without giving a finding.
Yes.
What is this? Did the court ask you to do all this?
my lord, I'm sorry for that, my lord. I'm sorry for that, my lord. I'm sorry for that, my
No,
lord.
no.
I have
Go
just
before the
asked.
trial court. Let the trial court decide.
Yes, my lord.
I'll vacate the status quo also.
My lord, no, it's not, my lord.
No.
My lord, see, the total extent is only
Nothing
6.
but a
my
pure
lord,
abuse of
No, no, my
process.
lord, its total extent is only 6.
Whatever
quintas.
it is, who asked you to do all that?
My lord.
Status quo means that
No, no, it's only an extent to 6 quintas of my land, my lord.
whatever
And,
it is,
my lord,
whatever
it
it is, why did your client do it?
My lord,
And
my
go
humble,
before the
my
trial
lord,
court,
my
let the trial
humble
court
submission
decide
is
it.
that
We
I'm
will
sorry
not.
for that, my lord. I will
There's
not
no
do that, my
sorry.
lord.
Why should you say
I will
sorry?
not do that. If that is the case, today evening itself, I'll see that I'll remove all the, whatever the paints are made, my lord. Today evening, I'll remove it, madam. By 6 o'clock, I'll see that it will be removed, my lord. Please.
Can I show to my lord what is their case, my lord? Please see their claim.
Only by evening 6 o'clock, I'll remove it and I'll just furnish the photographs tomorrow
Can't
itself, my
use
lord.
the process of this court
Please,
to,
my lord.
to do these kind of things.
My lord, whatever the, lord.
Where is that?
Please see page 20 of the writ petition.
Page?
20 of the writ petition is their claim.
Yes.
Now, please see, my lord, paragraph number 9. Paragraph number 9. It is submitted that MR5 or so and so was challenged by the plaintiff and his family members before the assistant commissioner so and so, and the same was allowed. Then para 10, it is submitted that the defendants have preferred the appeal before the deputy commissioner, challenging the assistant commissioner's order, and the same was allowed in 2020. This was allowed in my favor.
What happened? What happened after
They
this?
filed a writ petition. Writ petition came to be disposed of in 2024, where it was said that they have liberty to go and approach the writ petition, a fresh writ petition.
I'll hear you. I'll hear.
They have not produced the writ petition order before this honorable court. Then, my lord is pleased to see the cause of action. Para 12. It is
Para?
submitted, para 12 of the claim. It is submitted that the plaintiff continued to be in possession of the property for several decades. Then para 14. It is submitted that the defendants have approached the claim scheduled property around 1 p.m. on 13/3/26 and have threatened the plaintiff's peaceful possession over the property and tried to dispossess the plaintiff from the property. Now, please see their application, my lord, page 15 to the writ petition.
15.
Yes, sir. Interfering with the peaceful possession and enjoying the food scheduled property. Where they're showing it as vacant land. And their affidavit, my lord, please you see page 16, what they say. I submit that the suit is filed by the defendant for injunction and other relief. That's all. That's all their affidavit. Now, in contrast, my lord, please you see my statement of objection, my interim application under Order 39.4, where their writ petition, my lord, was dismissed, which is I think page 27. Along with my IA in page 27. In 2024, then my lord is pleased to see. I mean, I'm not going to trouble my lord on the title documents, but I'll just show my lord what is the state of the property. Please see, my lord, the in page 75. In page 75, with a conversion order in 2003 in my favor.
No, when you're seeking injunction,
Yes,
you
my
file
lord.
an IA.
No, first I'll make a
And an
submission.
affidavit in support of
My
it.
lord, I'll make a submission, my lord.
No, no.
My learned friend was making statements stating that
Forget about
I had
his case.
approached the deputy commissioner, my
No,
lord.
forget about his case. Please come to your IA that's filed seeking injunction, interim injunction. What is the necessity for grant of injunction? Please come to that affidavit. At page number 15 or 16. Come to 16.
50.
Basing on this, can the court grant, any court can grant injunction in your favor?
My lord, as per your lord's, my submission, your lordship is 10 days may be given to the trial court. Or I'll just draw a
An
lordship.
order
My
which
lord,
is in your favor is without any reasons.
my lord,
Court
then if
just
that is the
said-
case, my lord, whatever
Let's
the
see.
documents which he has furnished, I'll just read it out. my
I
lord.
will not go into his documents. Please confine to your case that you are entitled for an injunction and the trial court has not granted injunction to you. That I will consider. I will not look into any of the documents filed by the defendant.
My lord, I'm in position, my lord.
So where did you say, how it is? A civil suit cannot be filed in this manner.
My lord,
and you
I've
get
just
an
furnished those
injunction.
documents, my lord. I'll just.
Not documents. First of all, we will look at your plaint and the affidavit. That is what we are supposed to look at this stage.
My lord,
What did you say? What is the basis for you to be in possession of the property? What is the source of your title? And what is the interference by the defendants?
My lord, there is a, my lord,
interim
the
injunction?
annexes are there, my lord. I have just produced the annexes of the assistant commissioner which was passed by the revenue court stating that, I'll just read out the annexes of annexes. Assistant commissioner has passed the order in my favor, my lord. And they say that there is a fraudulent entry in the revenue records. These particular, my lord, these records which they have furnished before lordship, it is not pertaining to the village by name.
If you accept the order that you will go to the trial court, that's in your interest. If not, you will be compelling the court to pass an order which will be not in the interest of your client. That I'm making it very clear.
It may be, my lord, it may be, it can be, I will let the trial court consider all.
You are not entitled for a status quo order.
My lord,
as per the material that is
no,
there.
my lord, I'll just draw through the orders passed by the deputy
I will
assistant
not look
commissioner.
into all those orders.
My lord,
I am only look at the plaint and your affidavit and what have you filed along with the
I will
affidavit.
10 days time may be given so that the trial court may consider my application.
That's
my
it.
lord.
I will not continue
Please,
the status
please.
quo.
No,
order.
my lord, let the stay be there. Interim
Not
stay.
entitled for
My lord,
status.
today evening I'll see that all the
Please
paints
come.
which have been
The
marked.
present petition is filed.
My lord, today evening all the paints which have been they have
Yeah,
written, I'll
following
remove.
prayer. If you
Till-
want the status quo order to be continued, then I have to make observations why I am not convinced with that. Please understand.
Let the observations be made. Let the observations be made. my lord.
With regard to your,
Yes, my lord.
the present writ petition is filed, seeking the following prayer. The petitioner is agreed by an IA, that is, agreed by the order dated 26/3, agreed with the proceedings of the dated 26/3, 2026, whereby the court, instead of considering an IA number 1, has issued suit summons. Learned counsel for the petitioner submits that the coordinate bench of this court on 29/4/2026 has passed the following order within inverted commas. Heard, issue notice to the respondents. Parties are directed to maintain status quo in respect of the suit scheduled property till the next date of hearing. That interim order is continued on 9/6/2026, 8/6/2026, 9/6/2026, 10/6/2026. As due to paucity of time, the matter could not be taken up. Learned counsel for the petitioner submits that he is in possession of the property, and if the injunction is not granted, it would cause lot of hardship to the petitioner. This court has indicated that as the suit summons are returnable by 11/6/2026, and as already the respondents have filed their, defendants have filed their objections, the matter will be remanded, and the petitioner can argue the matter before the court. Land counsel for the petitioner insists that an order of status quo, what is granted by the court on 8 on 29/4 coordinate bench on 29/4/2026 shall be continued. Then counsel for the respondent submits that has relied on, so he has filed several documents which this court is not inclined to consider. However, it is submitted that subsequent to the status quo orders passed by this court, the petitioner has painted the number of the writ petition in the said premises, and the petitioner is in a way interfering, in spite of an order of status quo, has started interfering with the respondent's possession. According to the respondent is in possession of the property. When the petitioner is insisting for an interim order of status quo, this court wanted to convince itself with regard to what is the case of the plaintiff. In that regard, this court has looked at the plaint and the IA which is filed by the petitioner seeking an interim injunction restraining the defendant from interfering with his possession. At page number 16 of the page number 15 is the application where it stated that there shall be an ex parte ad interim order of injunction restraining the defendant and persons claiming under them from interfering with the peaceful possession and enjoyment of the property. Then when it comes to the affidavit in support of the IA, it is stated that he is a petitioner in the case and well aware of the facts. The suit is filed against the defendant for order of injunction. Where is that affidavit? Affidavit in support of the IA.
No, that affidavit is with respect to the plaint law.
It is not filed. Affidavit is not filed.
39 for the interim application, that affidavit itself is, it's not filed, my lord.
Why? Why? How can you not file the affidavit?
No,
before this court?
my lord, it was not filed. It is, I am not, that is not brought to the record of this honorable court.
Why?
Let's get tomorrow.
When you are questioning, are you not supposed to file the IA affidavit?
We'll file it. We have filed it, my lord.
No affidavit is filed before this court. The IA in support of the same. And considering the conduct of the petitioner after passing of an interim order by this court, an order of status quo. In the considered opinion of this court, that cannot be granted, that cannot be continued unless and until the court considers the matter, the IA on the merits of it. In that view of the matter, this court is disposing of the writ petition, directing the trial court to consider the pending IA within a period of 1 week from the date of receipt of the copy of the order. Yes.
My lord, my humble submission, till then there will be status quo, my lord.
Yes.
Bill number 5, preliminary hearing, Angry SV.
Yes.
I am for the petitioner, Your Honor. In this case, my lord, the petitioner is owner of shoe schedule property and he purchased in the year 1999 and he raised a loan from Vijaya Bank for purchasing this property, Your Honor. And
This is IA.
We have challenged IA number 8 in the suit, which has been rejected by the trial court. See, IA 8 has been filed, my lord, annexure H, page 88 to 92. Pages 88 to 92, annexure H.
Which page number is, where is the impugned order?
Impugned order is at page number 88 to 91.
88. Yes.
Yeah. We have sought for deposit of the arrears of rent
To pay monthly rent to the plaintiff, yes.
In this case, my lord, the Honorable Trial Court in IA number 1 filed under Order 38 Rule 5 has already issued order for attachment of the VRS benefit belonging to defendant number 2, Your Honor. That is in the year 22 itself. In 2022 itself, the Honorable Trial Court has issued attachment warrant for payment of towards rental.
What the court said was, you are saying that the defendant is a trespasser.
Yeah,
Ask the defendant to pay the rent.
because he only has admitted as a tenant in the security before the DRT securitization application, because he is claiming his right under a sham document, my lord. That is the lease agreement alleged to have been executed in September 99. That is 8 months after he became the owner.
We'll see when the respondent comes. Notice to the respondent.
He
Petition
became the owner,
forwarded
he is claiming. That's why, and he is also
on the council appearing for the respondent. If the memo is filed by 7th of July, list the matter on 8th. Yes. Only one with another respondent is there. The for R2 also there is a memo, I think. Look at it. Take that. It is served.
It has been duly served.
R2 also.
R2 also duly served, but not appearing, my lord.
But in the name of the memo is filed, stating that the petitioner has served the hand summons on R2. Notice to R2 is held sufficient in the name of R2 in the cause list. This is matter on 23rd in the first list. Yes.
Cell number 6. Cell number 6. Antajappa KMD.
I appear for petition. The petitioner is filed suit for recovery of money, my lord, 6,50,000. The suit was decreed as per compromise decree. Then the petitioner was filed the execution petition. The respondent is not paid the amount. The petitioner is execution petition, my lord. The execution petition, the petitioner was filed a IA for attachment of salary, my lord. The IA was allowed. The trial court impounded order, my lord, page number 41, my lord. Only 10% of the salary attached is lower side, my lord. Only enhancement, my lord. At least 1/3 of salary is attachment. The respondent is a lineman, KEB. He admitted the salary, my lord, 73,813.
His total earning is 73,813.
81 is JDR is
Deductions
spent.
are 32,075.
Salary is payable to 41,788. He also submit that he has to pay EMI so and so. Further net salary is 21,000. But accordingly, pay slip produced by the net salary payable decree order 41,788. Execution amount is 5,19,422. Hence, the fact and circumstance of the case, 10% of the salary is lower side, ma'am.
His salary is 73,000.
Yes.
He has shown deductions of 32,000. This money to be paid to the bank, this 15,000 EMI is also part of that. Part of 32,000 or excluding 32,000.
Balance is 41,788 is net salary, my lord.
Yes.
At least 4,000 is lower side, my lord. At least 16,000, 1/3 are as per section 61A of the CPC, my lord. Attachment. Gross salary.
Whatever, considering all that, your salary is 40, now your take home is now 41,788.
Only. And petitioner is the stroke person, my lord. Per month is 7,000 is medical necessary, my lord. Page number 40.
Out of that, he has availed the bank loan from ICICI Bank. There is a first page. In that, you have to pay EMI every month, 21,094.
So while attaching the salary, all your requirements has to be considered with the court.
And apart from that, his two sons are pursuing the studies. One is the engineer and also produce the document, study certificate, and also pay of the
City College.
No, for example, if your children, no, for your personal expenses, you require all this 41,788. Then in that case, there can't be any attachment.
No, that is why the trial court has rightly said that his salary is there, take home salary is only 21,000. Out of that, he has to pay the college fees and also one school fees. So college fees is 2,94,000 to the engineer for the one son, and another 64,000 to the another son who is working in the.
Then you are left with no money.
That is,
Even 5,000 also you can't pay.
out of his salary.
All that court need not consider, all your expenses.
That is why the court has clearly held that the 4,000.
Pay one third from
One
that
third is
41.
just, my lord, petitioner is a stroke person,
Up to
aged
pay,
person.
you have taken, there is a decree against you.
Try to see the other side also, because his grievances is that his two sons, he is looking after his family as well as two children. One is pursuing engineering as I submitted before.
Who will pay the money to him?
I also, I undertake that has been sent people to know that.
Outstanding amount is 5,19,422, and you will pay all your net salary is 73,813.
After deduction,
2023.
Take home salary is 21,000. Take home salary is only 21,000.
After deductions, it is
EMI.
41,788.
Sorry, 41,788.
In that one third amount,
Please.
one third amount of 41,788.
Kindly consider the documents which I placed before.
We need not consider all that.
Because he has to pay, look after his family and also for the.
He also has to recover his money.
Petitioner is the senior
This is
citizenship.
your problem.
And I have undertaken that if I get any other amount, lump sum, I will pay the.
This is not, the order is not correct. We'll ask the court, we'll pass an order on 41,788. One third of it should be deducted.
That is a highly difficult matter. I have to survive in the society matter. I have to look after my wife is also suffering seriously from ill health matter. That is why I have to bear the medical expenditure and also to the children also. One is study, two children also.
Then how will you honor the decree?
I will pay the.
2014, my lord. Decree was 2014, my lord.
Because my lord, I never denied, I am not going to pay the amount.
You will never deny, you will never pay.
Because already attachment has been issued to my salary at the 4,000 rupees. Every month I have not denied that. Yeah, every month they deny this.
What is the age of the petitioner?
Petitioner is at the 67, my lord, age is, and the stroke was there, my lord. Petitioner, Annexure J is
Please come.
medical expenses is per month is
agreed
7,000, my
order
lord,
passed
is
by the
necessary.
court Dated 3/10/2023, whereby the court has directed 10% of the salary and has directed 10% of the salary to be deducted. And accordingly, attachment warrant is issued. When counsel for the petitioner submits that the salary of the petitioner is the respondent is 73,813, and according to him, there are deductions of an amount of rupees 32,000, and the net salary payable is 41,788. It is the case that he has to pay the EMI and you would get his take home is 21,000. As such, the court has directed to pay 10% of the 10% of 41,725, 41,000.
41,788. 16,000 is the one third, my lord.
No, 41,788 in that
Net.
one third.
One third, my lord.
In 41,788, the court has directed 10% of it
Please.
to be paid. It is submitted by the land counsel for the petitioner that the petition is aged about 67 years. A decree was passed in the year 2014. Till 2014 till now, the respondent has not paid any. The judgment debtor has not paid any amounts considering his old age, and as one third of the amount is permissible, the court ought to have ordered the same. Then counsel appearing for the respondent submits that that he has to take care of the educational expenses of the children. He has to take care of himself and the wife. And as such, the court has rightly granted 10% of the amount. It is submitted that the respondent is not, never denied to pay the money. Next para, having got the counsels on either side, but it was a material on account. A decree was passed in the year 2014. Even till 2026, the said decree could not be realized. And the amount the amount is about 5,19,422. The petitioner, decree holder, is aged about 67 years.
And the stroke was there, my lord.
And is
And
having
7,000 is
suffering
medical expense per month.
The salary is 73,813, and petitioner with all the deductions and all, it is stated that he is receiving in 41,788. Even in that, the court cannot consider the submission that are made by the petitioner, and 1/3 of the salary, there is no, the 1/3 of the salary can be attached, and in that to the matter, the order dated 3/10/2023 is modified, and the trial, an amount of rupees 41, from 41,788. 41,788, 41,788, and 1/3 of it shall be deducted towards the shall be deducted. Yes. According to the order is.
One deducted from 21,000.
No.
Because only he is taking only 21,000. Out of that, can be added to.
All that EMIs and all is not the concern. Court is concerned with the deductions.
He has availed the loan from the bank. That is why.
You have availed the loan from him also.
First, borrowing the loan in 2000.
Only from the take home salary. That is why. My
Yes.
request. From
Then
the
number 7.
21,000.
Yes, next.
Cell number 7, Manjunath KB.
My lord, I'm before this honorable court on a attachment order, my lord. The executing court, my lord. My lord, kindly go to ink page 12, my lord.
What is in page 12?
It's the award, my lord. My lord, I'm the respondent is a company, my lord.
Hmm.
My lord, instead of filing the petition against the company, they have filed it against the personal assets of the managing director, which is not permissible in law.
This is micro, small, and medium enterprises.
Yes, ma'am.
Hmm.
Lord,
What is question before this court? This
my lord,
order.
the attachment order, my lord, the order, my lord, at ink page 61, my lord.
Mercedes car has been licensed. A Mercedes car not belonging to the petitioner, not the.
Have you questioned this award?
My lord, no, my lord, I'm the managing director, my lord. I'm not the, my lord, what a company has shut down, my lord.
No. This
My lord,
award is against whom?
It's against a company, my lord.
Let's see that.
Yes, my lord. Ink page 12, my lord.
It is hereby ordered that an amount of rupees 39 lakhs is due towards principal, the petitioner, the respondent company, with the material supplied shall pay the principal amount.
My lord.
Respondent is Silicon Industries.
No, no, my petitioner is Silicon, respondent is Rima.
Respondent in the
Rima Transformers.
Hmm?
Rima, my lord.
Rima Transformers and Conductors.
Private Limited. It's a private limited company, my lord. And I am the managing director of the private limited company, my lord.
That vehicle stands in whose name?
My name, my lord. Managing director. It says in my personal name, my lord.
Yes, what do you say?
This is what the petitioners have done, is not they have siphoned off money from the company
My lord.
and purchased not a Mercedes car and not several.
How do you determine it?
And not, this is covered by decision of the Supreme Court. It's what it is. Yeah, 1996 Supreme Court, 8/2007.
Take that.
My lord. There is not even a whisper anywhere, my lord. And here in the, after our arguments, he has brought this up, my lord. Nowhere, my lord. He has never said that anywhere, my lord.
Let's see what is that he's relying
Yes, yes,
on.
ma'am.
Yes.
The head note, second head note, this was on a, not a interlocutory application number 23, 27, 29. And not the personal properties of the managing director were ordered to be attached by the Honorable Supreme Court on account of defrauding the creditors.
That's a different case. Now, no, before going into the judgment, come to this impugned order. Was it all discussed? Was it all pleaded before the court?
This will not be petition, not the court below not have considered only one aspect, not that is whether or not the owner's name is mentioned as Diwakar M. Shetty, who has filed the affidavit annexed to this application. That is on page 9. Page 9 of the order.
My lord, 31, my lord, I have produced the document, my lord. My name is
The
clearly.
signatory and representative filed his affidavit. Without proper verification as to whether these properties belong to JDR company.
My lord, kindly go to ink page 31, my lord.
This is a, forget about this judgment. We have to look at the order. What is this order of the court? Where is the discussion? What is the basis for the court to reject this application?
No, then your ultimate to this. Let the respondent be permitted to place its not case before the court and let the hear the application again.
Yes, my lord. Yes, my lord.
Please come. The present petition is filed. I'll give the orders passed to 9 number 2 in execution number 479 of 2023 dated 30. Where is the date of the order? 35/24.
Yes, ma'am. My lord, 26/6.
I think it is 36 or something.
No, it is 26/6, 2025, my lord.
It says call on 26/6, 2024.
Oh, sorry.
There must be some other date.
30th May, my lord.
5, 2024.
24, ma'am.
Whereby the court has dismissed an application filed by the JDR. The JDR is before this court. The JDR has filed an application under section 151 CPC to recall the order dated 6/7/2023. It is a case that, basing on the application filed with the DHR, arrest warrant of the attachment warrant for the mobile properties was issued without proper verification. It is a case that the properties do not stand in the name of the company and it stands in the name of the director. The court, by order impugned, has rejected the application, and while rejecting the application, the court has observed that after perusing the attached documents to the list of mobiles, the name of the JDR company is not mentioned. Only the registration number is mentioned. The owner's name is mentioned as Diwakar M. Shetty, who has filed the affidavit annexed to this application.
That is my case, my lord.
The distance referred above are not come to the aid of.
That is the case, my lord.
That's what the distance referred above are not come to the aid of the JDR company. Therefore, there are no grounds to consider accordingly rejected. Then counsel for the petitioner JDR submits that when an award is passed against the company, the director of the properties belong to the director of the company cannot be attached. And when this is brought to the notice of the court having observed that the property stands in the name of the director, but still rejected the application, which is arbitrary and has to be set aside. Then counsel appearing for the respondent submits that the court has rightly rejected the application when the directors of the company has hyphened the entire amounts belonging to the company and purchased the properties
opposing that law and say that let it hear the matter.
No. I'm recording your submission.
My lord, that was never his case, my lord. It's never his case.
No,
Anywhere.
not rightly, not wrong.
Never.
The,
we
it is
argued
submitted that the court has rightly passed the order next per having for the council's consent. When an application is filed by the judgment debtor saying that the award is against the company and the properties of the JDR, the director are attached, court gives a finding that the vehicle stands in the name of the JDR and in the name of the director. Still, the court has rejected the application on the face of it. The order that is passed by the court is bereft of reasons and the same cannot be sustained. Accordingly, the order dated so and so is set aside and the matter is remanded back to the court for consideration, for fresh consideration on merits in accordance with law.
Respondent will be permitted to place on department all the materials.
Who?
A respondent.
He can always do it.
You
He can
do
always
it,
do it.
all the contentions are left open to the parties.
Yes, much of.
He's called the passwords in the 230 matters. First call the password.
Password matters. List number 1, serial number 22.
Lord, this matter, what has happened is an application that is filed for impleadment
Yes.
in a proceeding, my lord, is rejected by the court below.
What is the suit for?
My lord, it's a section 34 petition that is filed between a developer and a landowner. Award came to be passed in which the JDA between the landowner and the developer, my lord, comes to be set at naught. And the monies that were paid, my lord, is directed to be refunded back. My lord, in that property, my lord, I have taken a villa. I have paid money to the developer and both the developer and the landowner have jointly executed the agreement in my favor. My lord, in this section 34 proceeding, my lord, I make an application to implead myself saying one way or the other, if the award is, my lord, award has now set at naught the JD agreement. If the award is set aside and the property goes back to the landowner, to the developer for development, he may give it off to somebody else. If it goes back to the landowner, my lord, there is no way in which I will get the money back. Therefore, my lord, I said, please hear me. Just hear me and pass any order that you may want. The learned trial judge, my lord, please look at, my lord, along with the petition, my lord, I had not given, the order had not been released. I have now got the full order. The learned trial judge, my lord, while dismissing my application, says that my sale agreement is concocted way beyond the scope of the proceedings, my lord. Please look.
You are not impleaded.
No, my impleading application is rejected. I am only, my lord, I think what has weighed in the mind of the trial judge is that the suit is being directed by this court to be disposed of within some time frame. Late agate, sorry, they say that he feels that it may get delayed by impleading me. Hear me, my lord, that's all I'm saying. Hear me once. I have, and my lord, in another section 9 proceeding, my lord, in the same court, I have got an interim order, my lord, not to alienate or encumber. Where is the question of?
I appear for the caveator, respond number 3 to 12, my lords. I am the landowner. I have filed the claim petition, my lords, and now I am the respondent in the commercial arbitration, my lords. I have strong opposition to this writ
I'll
petition,
serve
my
a
lords.
copy on my friend.
I have a copy of the writ petition, my lords. I have strong opposition to this thing, my lords. I have evidence to show that the agreement itself is concocted. It's printed on a sheet of paper, my lords, which is not in circulation at the time at which the agreement was entered into.
It will be decided at the time of order 1 rule 10 itself.
Well, the very agreement that they're.
To be decided, first of all, once the person is before the court, then he will get an opportunity, you will get an opportunity to adduce evidence.
My lords, but the very application is filed based on a false document, my lords.
So at that stage,
Yes.
court cannot decide the, the veracity.
It will amount to
otherwise of
prejudging.
Huh?
It will amount to prejudging.
Even in addition to the same,
In
my
fact, your
lords.
lordships have consistently held there should be no mini trial at this stage.
In addition to the same, my lords, I have other legal grounds as well to oppose this application also.
What are the other grounds?
My lords, I am the master of the suit, my lords. I have filed the claim petition. I have not made them a party, my lords. And the continuing proceedings right now, my lords, it's just a continuation of the claim proceedings. Hence, my lords, they ought not to be a party to the
Whatever
proceedings.
the so-called fabricated agreement, what he is referring to, was executed by whom?
My lords, that agreement, my lords, it's purportedly executed by respondent number 1 and 2 and the petitioner. We are also made parties to it, my lord, but we have not executed it. We have not even provided a general power of attorney to execute it as well.
The case of the respondent number 2 and 3, 1 and 2 have executed in their favor.
Yes, my lords, in favor of the
Whatever
petitioner.
is the order of the court, it will have a bearing on, they will also be affected by that.
My lords, they can claim it under respondent number 1 and 2 is my argument. They can claim it under.
There is no separate suit.
There is a separate suit, my lords. There in the, if I say, my lords, that the agreement is valid, assuming that the agreement is valid, there's a provision for them to go on arbitration there as well.
The difficulty now the person is.
My lords, right now, it's at the stage of final hearing, my lords, final arguments. It has come before this honorable court, remanded back as well, my lords. In fact, it is posted today for final arguments, my lords. Deliberately, my lords, they are filing this thing, my lords, to delay the final arguments.
Your lordship may put me on terms that I will not delay, my lord, but hear me and pass the order. That's all I'm saying. Allow me to participate.
Let's have the decision, my lords.
Have a look at,
Paragraph number 26, please read.
just have a look at 23 onwards, my lord.
Yes.
23, document number 2 is the agreement of sale dated. On the face of it, it is clear that the said document is unregistered and unstamped. Clause 2 of the agreement contains a recital that the plaintiff developer has received 10 lakhs from the purchaser. The said clause does not contain any mention as to what mode or manner the said 10 lakhs has been paid. Has the purchaser paid the said amount in cash or check or through RTGS or through DD? Non-mentioning of the mode of payment creates a doubt in the mind of the court, and I have got hesitation to come to the conclusion that the said agreement is exactly what my friend is arguing. The defendants 3 to 9 are various letters of communication between the impleading applicant and the developer. The impleading applicant has produced letters to prove his communication. Nowadays, the normal course of communication is through commercial transaction, is through email. Impleading applicant has not assigned any reason as to why he has not communicated via email. On perusal of the above noted letters of communication, it appears there is no seal or endorsement of the plaintiff or developer, and the letters are not written on official letterheads. Hence, I have got no impediment to come to the conclusion. So letters are wrong, money is not paid, agreement is concocted. Then 26.
Para 26.
The document number 10 is the order sheet in commercial AA 137 of 26.
Between whom?
That is between me and the developer. He is not a party to that proceeding. Yeah.
I am a
only
party
not
to
to
the
alienate, my lord.
I am a party to the proceedings.
That's only
I
not
filed
to
my
alienate.
objections.
And in the very same court has granted me an injunction not to alienate. It is with respect to the,
Between you and the respondent and the other one, there is another suit, all of you are parties to that.
Yes, my lords.
but that is
There
on-
is.
that's
there
a
is.
section 9. 1 minute.
Yes, please.
That's a section 9 proceeding. This is for enforcement of the award. If the award comes to be set aside, my lord, let us just assume for the sake of argument that the landowner and the developer may not collude and something happens as a result of that, my rights will be affected. Hear me, my lord, and what sort, I mean, this kind of blanket, I will be, the conclusion reached by the learned trial judge that I will not be affected by any order passed is wrong. Lord, whether my presence,
Secretly, the impeding application did not take any steps to impede himself in AC number so and so. As the impeding applicant did not take steps to contest before the arbitral proceedings, I am of the view that even in the absence of the present impeding applicant, this court can effectively.
I didn't know about it, my lord. I only came to know about it in 25 and therefore immediately thereafter I filed the application. Then you please look at 28. Pertinent to note that the High Court has issued directions to decide the case within so and so. Your lordship may put me on notice. Learned counsel appearing for the defendant relied upon the principles laid down in Kasturi versus. Now clear that the two tests that are satisfied with determining the questions who is a necessary party or so and so. But I may be not necessary, but I may be a proper party, my lord.
My lords, they're neither a proper nor a necessary party. The tests that are laid down in this judgment, my lords, are that the first and foremost test, my lords, is that whether in the absence of the party can an effective decree be passed.
You have an agreement or a.
Agreement of sale.
Agreement.
Agreement of sale.
What is the dispute between two of them?
Pardon, my lord?
What is the dispute between two of them?
The dispute between the landowner and the developer is that within the time that was stipulated in the joint development agreement, the construction was not put up.
It is pertaining to a vast extent.
No, but very same land, my lord.
No, it's a vast extent
No,
of
no,
land.
it's
Yours is agreement is in respect of a property.
One villa.
One villa.
with
That is
respect
in
to,
respect of a larger extent.
that's.
They can't enforce their rights. I'm sorry. They have a separate proceedings there, my lords.
And pass orders. Heard resolved.
Please. My lords, may I place on record decision of
Take that.
23 serial number.
Lord, would your lordship just say trial court not to precipitate till the judgment is passed? I'll tell your lordship
Well, that's
why.
the argument set
No,
today.
1 minute.
No, I'll pass orders on Wednesday. Post this matter for judgment on Wednesday till such time not to.
Please, my lords.
Trial court not to precipitate.
Yes.
23. 23. Kevin Narasimhan.
Lord, in 23, I appear for the petitioner.
Yes.
Lord, Annexure H communication is the impugned order herein, Lord. Lord, the petitioner herein, Lord, is owner of certain chunks of land in Tumkur districts. Lord, the respondent authorities, my Lord, without acquisition, without my consent, laid down, my Lord, high tension electricity wires and, my Lord, electric poles in my property.
Have you informed him?
We have served it, my Lord. It's already served.
Mr. Devraj.
Please, ma'am.
Mr. Devraj.
The base
It is served, ma'am. I'll,
Mrs. So-and-so is right to take notice. Which are the respondents?
all are BESCOM.
All are Westcom only.
Please, ma'am.
Mr. Devraj is right to take notice on behalf of respondent 1 to 6. I'll have it in the first list tomorrow.
Please.
Print the name of Mr. Devraj. Yes, next.
I request for Monday, my Lord, so that I can serve. Monday.
No,
first
if
list.
you have no urgency, I can take it up on Monday also.
I'll serve him, my Lord. Serve my copy.
Monday.
Monday first list.
First list.
Please. Great.
Yes.
30 mood matter, list number 2, serial number 121. Urgency pleaded matters.
Lords, for petitioner in this case, Lords, the case is of money recovery suit, my lords. And I am the dependent number 1 in the suit, my lords.
What is urgency?
Lords, the case is posted today for defense evidence, my lords, and the plaintiff had filed an application to attachment before the judgment, my lords. I am the government employee, my lords, working in High Court of Karnataka itself. My lords, the plaintiff had filed the suit is of 2 lakhs, my lords. And
Let's see
contention.
No, let's see that IA, that order in the IA.
Please, my lords. My lords, I had filed a memo, my lords. That order is produced separately, my lords. Order dated 24/1/2026, my lords. The application pertains to referring my thumb impression and signature to forensic expert, my lords. Lords, my contention is that I am nowhere party to the promissory note produced by the plaintiff
This
before the
application is rejected. We will see, let notice go to the respondent.
No, the reason may be noted, my lords. The reason is in page number 9, my lords, last 4th line, my lords. If my lords could produce, my lords.
No, whatever it is, your IA for IA is dismissed. We'll see. There is no urgency for this. Let notice
Please, my
go
lords,
to the
but
respondent. Notice to the
my lords,
respondent.
respondent had filed an IA for attachment of my salary account, my lords. I'll be hampered, my lords, if stay is
No,
not
that is
granted, my lords.
No, that is a different application. Court has to pass orders. If the orders are passed, you
Please.
have a remedy. The
Please,
notice to
my
the
lord.
respondent to take court handsome on the counsel appearing to the respondent and file a memo to that effect. Yes.
List number 3, serial number 52. List 3, serial number 52. Warning mentioned matter.
Yes. That's it. Now,
My lord, sir, mine was serial numbers 8. I just missed. Mine was the next matter. I just request for any.
it will be there tomorrow.
First list, if I may request. I just missed it.
No. Before all of you make mention, what we do is, instead of having these many lists, whatever the matters are there in the list, what I am proposing to do is, now today we have completed till 7. So from every 20 matters from this list, today itself the court officer will be giving the dates in the first list, like tomorrow, day after tomorrow, like that. When we have looked at it, by July 2nd, we'll be completing this entire list, if that's the manner if we go. So, and wherever the interim orders are there, they will be extended. Like if their matter is coming up before the court any day, you can come and make a mention. Even if it is adjourned, I will take up on the day in the afternoon. So that instead of having these many matters in the list. Huh? Huh?
Serial number 10 in the second list.
Tomorrow it will come.
Tomorrow.
Till 18 tomorrow, it will come till 17 tomorrow. Remaining matters from Monday, all will be, and fresh matters will come as it is. These matters will come in the first list. So every day, whatever comes will reach.
List 3 for 46, my lords.
List 3?
46. July, sorry, 20th ಆದ್ಮೇಲೆ ಕೊಡ್ಬೋದಾ?
No, it will go to July, don't worry.
My lord, list 3,
My lords, list
93, serial number 93, my lord, there's payment of rent. So that was a date given matter for today. The respondent has not paid the rent. There was no stay as such. However, it was to be heard finally because the rent is 54 lakh.
Can't hear it finally.
54 lakh rupees non-payment of 93.
Third list.
92, my lord. Serial number, list 3, 92. Could not make a mention in the morning.
What we do is, you please, all of you wait till Monday. Now the manner in which I've said, they will now give the dates to all by extending the interim orders. Like on everyday morning, whenever you have this thing, you can mention. Now we will not,
yes.
So please don't mention any of you.
My lord,
Serial number
25,
list number 3,
my lord. Serial number 64 and 65, there's an order of eviction, there's a threat of eviction. We taken up tomorrow, my lord. Because there's also a wedding in the very same house.
The number?
64 and 65.
In which list?
List 3.
Fresh matter it is?
It's not been admitted, my lord. It's not a fresh matter, it's not reached, my lord.
Which year is this?
My lord, 2026.
2025.
2026, man.
64.
Yes, list 3, serial number 64 and 65. There's an order of eviction, my lord. The relationship itself is disputed. I am in possession with respect to a sale agreement, my lord. They have filed
Even when did you file this writ petition? I mean CRP?
In the month of March.
It's a whole problem. Everybody has urgencies whenever
may
you
request on Monday, my lord, because there's an order of eviction.
Today, I don't want any of you to make any request. Let this arrangement, let them post the matters. We'll see.
A date may be fixed, my lord.
We'll see. Date will be given. Now you'll know by end of the day. She has already written on this.
There's a wedding in the house in the month of last week of this month, my lord.
We'll consider.
Serial number 25,
On
list number 3.
22nd, you make a mention.
Serial number 25, list number 3, my lord. Lower court, day today, date has been given, my lord. 18th, date has been given by my lord.
What is today?
My lord, today is the 10th, my lord.
So, you will be making a mention on 17th. I will take up on 17th at 2:30. So, you don't have to worry and mention it 10 days before.
Hand notice has been served on the respondent, bank matter, commercial court matter, my lord.
Please understand,
Please,
all this is not possible. Court is trying to do its best. Yes.
This date may kindly be given, my lord, for this 17th May, at least 76th.
I will not give any date today. I said, whenever if the matter is coming, on that day, you people can make a mention. I'll consider it and take it up at 2:30. And whatever date matters and all, they will be coming in the second list. All these matters will come in the first list. In everything you write in the first list. On so and so date in the first list.
May I request at least next week a date may be fixed, my lord.
ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಇವಾಗ
What officers, madam?
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ
ಹಾಗೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮೇಡಮ್?
ಒಂದ್ ನಿಮಿಷ ಇದ್ರೆ ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿ ನಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಅದ್ರ ಪ್ರಕಾರ ನಾನು ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಕೇಳಿಸ್ಕೊಳ್ಳಿ. Whatever the matters which are not reached in list number 2, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಇಂದ 17 ವರೆಗೂ ನಾಳೆಗೆ. ಹಾ. ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ 18 to 38 ಮಂಡೇ, 39 to 59 ವರ್ಗುನು 16th ಜೂನ್, 59 to 79 17th, ಆ ತರ 20 ಮ್ಯಾಟ್ರ್ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಡೇಟ್ಸ್. ನೀವು ನೋಡ್ಕೊಳ್ಳಿ ಅವತ್ತು ಲಿಸ್ಟ್ ನಾಳೆಗೆ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ. ಇವಾಗ ಲಿಸ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ ಸರ್, ನಿಮ್ ಮ್ಯಾಟ್ರ್ ಅಪ್ಡೇಟ್ ಅಂತ. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ನಲ್ಲೂ 20 ಮ್ಯಾಟ್ರ್ ಹೇಳಿದ್ರಲ್ಲ, ಇವತ್ತಿಗೆ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. ಐ ವಿಲ್ ಅಸೈನ್ 20 ಮ್ಯಾಟರ್ಸ್ ಪರ್ ಡೇ ಅಂತ ನೀವು ನೋಡ್ಕೋಬೇಕು. ಅಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಡೇಟ್. ಈವ್ನಿಂಗ್ ಬೈ ಈವ್ನಿಂಗ್ ಯು ವಿಲ್ ಗೆಟ್ ದ ಡೇಟ್ ಆನ್ ವಿಚ್ ಡೇಟ್ ಯುವರ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿ ದೇರ್ ಅಂತ. ಇವಾಗ ಎಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್. ನಿನ್ನೆ ಆಗಿದೆ. ನಿನ್ನೆ ಎಂಟ್ರಿ ಮಾಡೋ ಪ್ರೀವಿಯಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಿನ್ನೆ ಆಗಿರುತ್ತೆ. ನಿನ್ನೆಯಿಂದ ಇವತ್ತೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆದಾಗ ಆಗುತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಬೇರೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗೇನೆ ಲಿಸ್ಟ್ ಆಗೋದು ಸರ್. ಸರ್ ಎಲ್ಲ
Madam, court officer. Court officer, madam. Court officer, madam. ಮೇಡಮ್ ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಇಲ್ವಾ?
Excuse me, court officer.
Court officer.
So list 2, serial number 89.
Court officer, uh, can you please let me know whether the matter like serial list number 2169, like these matters will again be listed in the serial order? Well, I could not hear that, sorry. If you can clarify. Court officer, is there a direction for listing the matters, remaining matters of list 2?
ಹೇಳಿ ಸರ್.
Is there a direction for listing the matters of list 2? Mine is list 2 169.
Sir, list 2 and 3 in both the lists every day the 2020 matters will be added up to list number 1. Like
Oh.
that all the matters are attended.
All right. No.
ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ? ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ?
ಸರ್ ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ, ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಯಾರು ಹೇಳಿದ್ದು?
ಸರಿ, ಓಕೆ.
Court officer, madam, list 3 serial number 46 adjourn ಆಗಿದೆಯಾ? Court officer, madam. Court officer?
42 ಒಂದಿಲ್ಲ, 41 1 2
Court officer?
62 24 7.
Court officer, madam.
37 ಆಗುತ್ತಲ್ವಾ? 37
Court officer, madam.
67 63 ಇಂದ ಸರ್ ಹೇಳಿ ಮೇಡಮ್.
Madam, list 3 serial number 46 adjourn ಆಗಿದೆಯಾ? Court officer, madam, list 3, serial number 46.
97 20 ಮ್ಯಾಟ್ರ್ ಸೇರಿಸ್ಬೇಕಿತ್ತು. 97 ಗೆ 5 ಇದೆ, ನಾಳೆ ನೋಡೋಣ. 97 ಗೆ 5 ಇದೆ, ನಾಳೆ ಏನಾದ್ರು 97 ಗೆ 5 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಬರ್ಕೊಂಡಿರ್ತೀವಿ. ನಾಳೆ ನೋಡ್ಕೊಂಡು ಉಳಿದಿದ್ದು 97.
Madam, list 3, serial number 46 ಸ್ವಲ್ಪ ಹೇಳ್ತೀರಾ?
Madam, ಎಲ್ಲ matters each day 20 matters will be added up to the first list. ಎಲ್ಲ ಈಗ ಏನ್ ಎಂಟೈರ್ ಲಿಸ್ಟ್ ರಿಮೈನಿಂಗ್ ಏನ್ ಉಳ್ಕೊಂಡಿದೆ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಪ್ರತಿದಿನ 20 ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಡ್ ಆಗುತ್ತೆ ಆಸ್ ಪರ್ ಕ್ರೋನಾಲಜಿಕಲ್.
Okay, madam, thank you.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಏನಾಗುತ್ತೆ?
ಸರ್ ಅದ ಬರುತ್ತೆ ಅವತ್ತು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಅದು ಅರ್ಜೆಂಟ್ ಆಗಿದೆ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಡೇಟ್ ಹೋಗುತ್ತೆ. ಈಗ ಸಂಜೆಗೆ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಸರ್, ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ, ಡೇಟ್ಸ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ನಿಮ್ಮ ಮ್ಯಾಟ್ರ್ ಯಾವತ್ತು ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ, ಅವತ್ತಿಗೆ ಬನ್ನಿ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಏನಾಗುತ್ತೆ ಮೇಡಮ್?
ಇವ್ರೆ ನೀವ್ ಹೇಳ್ದಂಗೆಲ್ಲ ನಾವು ಕೇಳಕ್ಕಾಗಲ್ಲ, ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ ಏನಿದೆಯೋ ಅದನ್ನ ಮಾಡ್ಬೇಕು. 18th ಇಂದ ಮಂಡೇಗೆ ಇರೋದು, ಕೇಳಿಸ್ಕೊಂಡ್ರ ಬೆಳೆ ಅವಾಗ್ಲೇ ಅಪ್ ಟು ಟಿಲ್ ಅಲ್ಲ 17th ಅಪ್ ಟು 17 ವರ್ಗುನು ಲಿಸ್ಟ್ 1 ಟುಮಾರೋ, ರಿಮೈನಿಂಗ್ ಅದು ಡೇಟ್ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಆಗ್ತಾ ಹೋಗಿ. ನೀವು ನಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಕೇಳಂಗಿಲ್ಲ ಇವ್ರೆ, ಆಸ್ ಪರ್ ಡೈರೆಕ್ಷನ್ಸ್ ಐ ವಿಲ್ ಬಿ ಅಸೈನಿಂಗ್ ದ ಡೇಟ್ಸ್. You have to look into the updation wherever that whenever your matter comes you have to see it and come for arguments. ಗೊತ್ತಿಲ್ಲ ಇವ್ರೆ, ನಾಳೆ ಬರ್ತಿಲ್ವಲ್ಲ 18 ನಿಮ್ಗೆ ಬರ್ತಾ ಇಲ್ಲ ಲಲಿತಾ, ಒಂದ್ ಸ್ವಲ್ಪ ವಾಪಸ್ ಕೊಟ್ಟಲ್ಲ
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಎಂಟ್ರಿ ಮಾಡುವ ಅಲ್ಲ ಇವಳೆ ಬಾ ತಗೊಂಡು ಅದು ನೀನ್ ಎತ್ಕೊಂಬಪ್ಪ, ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಸೆಪರೇಟ್ ಮಾಡ್ಬೇಕು, ಮತ್ತೆ ನಾವು ಡೇಟ್ ಆಡ್ ಅಪ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಮೇಡಮ್
ಇವ್ರೆ ಡೇಟ್ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಸಂಜೆಗೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, by evening the date will be updated in the computer, you see it there, you will come to know on what date your matter will come.
Court officer,
ಹೇಳಿ ಮೇಡಮ್.
ma'am, serial number 89, list 2, serial number 89.
ಮೇಡಮ್ ಅದೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ, ಡೇಟ್ ನೋಡ್ಕೊಂಬಿಡಿ, ಡೇಟ್ ಈಸ್ ಅಸೈನ್ ಟು ಯುವರ್ ಮ್ಯಾಟರ್, ಯು ಇನ್ ದ ಬೈ ಈವ್ನಿಂಗ್ ವಿ ವಿಲ್ ಅಪ್ಡೇಟ್ ದ ಡೇಟ್ಸ್ ಇನ್ ದ ಕಂಪ್ಯೂಟರ್, ಯು ಸಿ ಇಟ್.
Okay ma'am, thank you.
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೀರಾ, ಅಪ್ಡೇಟ್ ಆಗುತ್ತಾ?
ಇವತ್ತು ಏನೇನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ಗೂ ಡೇಟ್ ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಪಾ, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ 18 ಮಂಡೇಗೆ ಹೋಗಿದೆ, ಎಷ್ಟು ಸತಿ ಹೇಳ್ಬೇಕು, ಅಪ್ ಟು 17 ವರ್ಗುನು ಅಪ್ ಟು 17 ನಾಳೆ ಸರ್. ಫ್ರಮ್ 18th ಇಂದ ಇಲ್ಲಿ ನೋಡಿ, 18th ಇಂದ ಮೇಡಮ್ ಓನ್ಲಿ ರಿಟರ್ನ್ 18th ಮಂಡೇ 18 to 18 ಸರ್. ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಸರ್.
ಲಿಸ್ಟ್ ಸೀಲ್ ನಂಬರ್ 96 ಸೊ ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ,
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಬ್ರೇಕ್ ಆಗಿದೆ,
ಬ್ರೇಕ್ ಆಗಿತ್ತು, ಮಾಡಿಸಿದೀವಿ ಇವ್ರೆ, ನೀವು ನೋಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಂಡು. ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ ಇನ್ನು ಆರ್ಡರ್ ಕಂಪ್ಯೂಟರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ ಸರ್? ಅಪ್ ಟು 38 15/6 38 ಅಪ್ ಟು. ನೀವು ಈ ಫೋಟೋ ತಗೋಬೇಡಿ ಸರ್, ಮೇಡಮ್ಗೆ 20 ಮ್ಯಾಟ್ರ್ ಅಡಪ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ ಒಂದೊಂದು ಮ್ಯಾಟ್ರು ಆರ್ಡರ್ ಆಗೋಯ್ತಲ್ಲ, 230 ಮೂವ್ ಮಾಡಿರೋದು ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ 20 ಮ್ಯಾಟ್ರು ಅಪ್ ಟು 38 15/6 39ಇಂದ. ಸರ್ ನೀವು ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಈ ಕಡೆ ಹಿಂದೆ ಬರ್ಕೊಂಬಿಡಿ, ನೀವು ಕಾರ್ ಲಿಸ್ಟ್ ಬಿಟ್ಬಿಡಿ, ಹಿಂದೆ ಕಡೆ ಬರ್ಕೊಳ್ಳಿ, ಹಿಂದೆ ಕಡೆ ವೈಟ್ ಪೇಜ್ ಇದೆಯಲ್ಲ ಅದು ಕೊಡಿ. CL ನಂಬರ್ 18 to 38 15/6 15/6 39 ಇಂದ 58 ವರ್ಗೂ 16/6 59 ಇಂದ ಸರ್ 59 ಇಂದ 79 ವರ್ಗೂ 17/6 80 ಇಂದ 80 ಇಂದ
ಏನಿಲ್ಲ 65 ಲ್ಯಾಂಡ್ ಡೇಟ್ ಆಗ್ತದೆ.
ಲಾಂಗ್ ಡೇಟ್ ಹಾಕಕ್ ಬರಲ್ಲ, ಹಂಗೆಲ್ಲ ನಮಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ. 17/6 ಆಯ್ತಾ? 80 ಇಂದ 99 ವರೆಗೂ 18/6 100 ಇಂದ 120 ವರೆಗೂ 19/6 122 to 141 22/6 142 ಇಂದ 161 ವರೆಗೂ 23/6 162 ಇಂದ 181 ವರೆಗೂ 24/6 182 ಇಂದ 201 ವರೆಗೂ 25/6 202 ಇಂದ 221 ವರೆಗೂ 29/6 ಆಯ್ತಾ? 222 ಇಂದ 241 ವರೆಗೂ 36 242 ಇಂದ 260 ವರೆಗೂ 17 ಆಮೇಲೆ ಥರ್ಡ್ ಲಿಸ್ಟ್ 1 to 20 17 27 21 ಇಂದ 40 37 41 ಇಂದ ಅಂದ್ರೆ ಮಧ್ಯ ಹೋಗಿದೆ ಅದು ನೋಡ್ಕೊಳ್ಳಿ ಅದು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಲ್ವಾ 62 ವರೆಗೂ 67 ಆಯ್ತಾ 63 ಇಂದ 82 ವರೆಗೂ 77 83 ಇಂದ 102 ವರೆಗೂ 87 ನೆಕ್ಸ್ಟ್ 97 ಇದೆಲ್ಲ ಫುಲ್ ಲಾಸ್ಟ್ 10397 ಸರ್ 9097
ಮೇಡಮ್ 29305 ಅದು ನೆನ್ನೆ ಇಲ್ಲ, ಅದು ಮೊನ್ನೆ ಇತ್ತು ಅಷ್ಟೇ.
ಮೊನ್ನೆ ಇದ್ರೆ ನೆನ್ನೆ ರಿಪೀಟ್ ಆಗ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ ಹೊಡೆದಿದ್ದೀರಾ ನೋಡಿ.
ನಾನು ಹೊಡೆದಿಲ್ಲ ಇವಳೆ. ನೀನು ಹೊಡ್ಕೊಳ್ವಾಗ ನೀನು ಹೊಡ್ಕೊಂಡು ನೋಡು, ಇಲ್ಲಿ ಹೊಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಿ ಇದು ಹೊಡ್ಕೊಳಕ್ ಹೋಗಿ ಅದನ್ನು ಹೊಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ರೆ.
ಅಲ್ಲ ನಿಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ನನ್ನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹೊಡ್ಕೊಂಡಿಲ್ಲ ಇವಳೆ. ಇದೆ
ನೋಡಿ ನಿಮ್ ಇದ್ರಲ್ಲಿ.
ಇಲ್ಲ ನೆನ್ನೆ ಲಿಸ್ಟ್ ಅಲ್ವಾ? ನೆನ್ನೆದ ಮೊನ್ನೆದ?
ಅದೇ 10ನೇ ತಾರೀಕು.
10ನೇ ತಾರೀಕು ನೆನ್ನೆ.
10ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಅಲ್ಲಿ 134 ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್.
ಲಿಸ್ಟ್ 2 ಅಲ್ವಾ?
ಲಿಸ್ಟ್ 2 134 ಹೊಡೆದಿದ್ದೀರಾ ತಾನೆ?
ಇಲ್ಲೇ ಇವೆ.
ಇಲ್ಲಿ ನೋಡಿ
ಡೇಟ್ ಬರ್ಕೊಂಡಿರೋದು ನಾನು 77 ಗೆ 77 ಅದು
ಇಲ್ಲಿ ಹೊಡೆದಿದ್ದೀರಾ. ಅದು ಬೇಡ ಅಂತಾನೆ ಹೇಳಿರೋದು ನೀವು.
ರವಿ ಪಾತರದಲ್ಲಿ ಇದೆಯಪ್ಪ, ಅವಳಿಗೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತು SMC ಗೆ. ಇದೇ ನೆನ್ನೆ ಡೇಟ್ ಅಲ್ಲಿ ಒಂದ್ ಮಾತ್ರ ಮಿಸ್ ಮಾಡಿರೋದು ಅವ್ರು.
ನಾನು ಒಂದ್ ಮಿಸ್ ಮಾಡಿದೀನಿ. ಹೌದು,
ಈಗ ನಾಳೆ ಅದನ್ನ ಸೇರಿಸ್ಬಿಡ್ತೀನಿ.
SMC ಕೊಡ್ಬೇಕಲ್ವಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅದೇ ಜಾಗಕ್ಕೆ ಸೇರಿಸ್ತೀನಿ. ನಾನು ಎಲ್ಲಿ ಮಿಸ್ ಮಾಡಿದ್ನೋ
ಅಲ್ಲಿಗೆ ಸೇರ್ಸಕ್ಕೆ ಎಲ್ಲಿ ಬರ್ತದೆ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅದು ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ಅಲ್ಲಿ ಇತ್ತು ಹೇಳು?
ಅದಾ ಲಿಸ್ಟ್
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 200.
ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಡೇಟ್ ಕೊಟ್ಟಿದೀವಿ, ನೀವು ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಈವ್ನಿಂಗ್ ನೋಡ್ಕೊಂಡ್.
ಹೌದಾ ಮೇಡಮ್? ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ ಮೇಡಮ್?
By evening, we will update the dates on which your matter is coming. Please, you look into that updation.